cannot hear you. Item number 18. Yes, what do you want? The 2017 matter, the criminal revision petition. You are there. Why are you not prepared? Hmm? You should have looked into the file.
Return to the party. All about it. You need some time to verify.
Item 17.
18. 1
Your name? M. Jha. No, your name. Heard MS M. Sahu, learned counsel for the petitioner who. Have you informed the other side? No, no. What about R2, Mr. Kalita, Mr. Das? Please don't make a mention without informing the other side. All right. You wait when the matter is called. You make your prayer. Yes.
Item number 9, Logic. My senior Mr. Tika Luka. Logic, in this matter, Rob, I would have returned the file Logic already. Wrongly listed my signal name Logic. And
Who is now the conducting counsel? Item number 9. And Mr. AC, actually, you wait, let the matter be read, but don't leave, huh? Fill asylum.
Logic, item number 10, Logic. Kindly adjourn for the day Logic.
Why?
File some misplaced Logic.
What is this excuse that is repeatedly being made before this court for the last 2 weeks? Whenever the matters are rolled, file misplaced, file misplaced. Displacement of files cannot be a ground for adjourning matters. Yeah, there are other ways by which you can reconstruct the records. You can apply for certified copy, reconstruct it. What is this repeated grounds in all file? You wait. Let's see when the matter is called. Please call out the list.
Number 1.
Yes, Mr. Gautam?
Item number 2.
Yes, Mr. Das?
Logic. Logic, this is an appeal against the audit, when audit in 2011.
One second. File is not yet paid. You are a legal aid counsel?
Logic
Here for the appellant.
for them.
Why so many counsels' names shown?
Not only space the evidence privately filed this appeal, but thereafter they stopped pursuing the matter. So thereafter,
And why are there 2 appeals?
because different sets of evidence,
How many accused total?
total Lordship 8 Lordship.
You are for the APP?
Yes.
Total how many accused?
8.
8 accused. And how many are there in item number 2?
That is 5.
5. And in item number 3? All of them.
Same tax.
Okay. You are holding which brief? 2?
Logic can take criminal appeal 179.
1?
170. Basically, it's the same ground.
Yes.
Lordship, now, by judgment order dated 23/8/2011, the Learned Court of Session Sagar had convicted the accused appellants in this case under section 149 and 304 part 2. Lordship. Now, Lordship may come to the FIR that is at page
30?
304 part 2, Lordship,
Part 2.
and 148 punishable under 149.
Yes.
The Lordship needs to come to the FIR that is at page number 1.
Yes.
The paper will Lordship. The operating part, Lordship, will be at page number 4.
Page 4. Flag 2. Yes, please.
Lordship, page 4. Uh, subject, Ezahar, sir, humble submission is that around 10:30 a.m. on 7/3/2004, the below mentioned accused persons, along with some others, assaulted my brother Sri Nathu Borogahai on his head and various part of his body with dowels, sticks, etc., and thus caused grievous injury to him. I immediately admitted my brother to Sibsagar Civil Hospital, but around 9:30 a.m. today, that is on 8/3/2004, my brother died. That's the lodging of the Ezahar got delayed as I was busy with my brother's treatment. And the name of the
One day. 1 day after.
1 day.
Yes.
Now, Lordship, before going into the statements of the evidences, I would like to take your Lordship to the judgment first.
No, why judgment first?
As the Lord, because there's certain facts which later on, while going to the evidence, will be very easier to.
Let's see the evidence because
Gotcha.
as an appellate court, I have to look
Right.
into the
Gotcha.
evidence.
Gotcha.
We'll first find the evidence
Gotcha.
and then we'll see
Gotcha.
why the order of the conviction is bad according to you. And for that, you may point out whatever you want to show from the case.
Gotcha.
Right?
Now, Lordship, I then come to page number 10. That is the deposition of PW1.
Now, this case is based on circumstantial evidence or
I don't think evidence, basically. Because they were seen with the, but thereafter, later on the next morning,
nobody have seen the accused beating the.
no one. The evidence is, even though the evidence is not declared anywhere, but the deposition of PW1.
Where is the commitment order?
Lordship, that is at page number 145. That's it.
144.
Lordship.
Okay. Now PW1.
PW. On board, I know accused Anand Changmai, Saso Changmai, Ranjan Changmai, Babu Changmai, Sanjeev Changmai, Latu Changmai, Vikas Changmai, and Jyotimoni Kumar, who are present in the court. Deceased Nathu Borogahai was my brother, and the accused persons I have
So
mentioned
PW1 is the informant.
is the informant. Is the brother of the deceased.
Yes, please.
Was my brother, and the accused person I have mentioned today assaulted him to death. The incident took place about 3 years back.
That's all you want to bring.
That day, I
Yeah.
went to Sibsagar town to do shopping. I returned home from Sibsagar town at around 2:30 p.m. My mother, Tuniro Puragomai, told me that the incident, that accused Saso Alais, Anand and Sanjeev Sangmai tied Nathu and took him to Koregaon.
Is the mother examined?
The mother has not been examined, Lordship.
Okay.
Now, Lordship, thereafter, then I went to Charaguri. I did not get any clues there. When I reached near Namgarh, a prayer hall used by Vaishnavite Hindus in Assam at Karigaon, I asked the person and he told me that police had arrested a boy from there. I came to Sibsagar police station therefrom and came to know that Nathu Borogahai was taken to the civil hospital. I found Nathu in the civil hospital while he was undergoing statement. I saw bleeding injury on Nathu's head. Now, Lordship, the next part is very relevant. When I asked Nathu, he told me that Sanjeev Changmai, Ananta Changmai, Tarun Changmai, Babu Changmai, Vikas Changmai, Dudumani Changmai, Ranjan Changmai, and other persons assaulted him with rod and stick. This was a statement which he made, Lordship. Even though there is no dying declaration to that effect, recorded dying declaration, Lordship. But this was presumed to be a declaration, Lordship. Thereafter, Lordship, the sun was about to set when I reached the hospital. I was at hospital till 9 p.m. Subsequent to my arrival there, Nathu became speechless at about 7 p.m. I came home around 9 p.m. Nathu died around 9 a.m. the next morning. After Nathu's death, I lodged an Ezahar with the police station. Exhibit 1 is the Ezahar. Exhibit 1 is my signature. Police held inquest on the dead body. Exhibit 2 is the inquest report. Exhibit 2-1 is my signature. After the postmortem examination, the body was handed over to me. Police came to the place of occurrence. The police seized the shirt, pant which were in the wearing of the deceased. Exhibit 3 is the scissor list. 3-1 is my signature. Police recorded my statement. Police seized the gamusa, a traditional hand-woven towel, and a bamboo stick from the place of occurrence. I do not know why the accused persons killed me. During cross-examination, Lordship, my mother, Tuniro Puragomai, is still alive. I live at village Gorpush. I was living separately from Nathu. Village Doraputa can be reached from the village Gorpush via Naujan. I heard the incident took place at village Gorpush. The same village is about 3 kilometers away. I know Nalia and he is from Naujan. there was a wedding ceremony in the house of Nalia the day before the incident. I saw only one blood injury on Nathu's head in the hospital. Now, this is something which he had admitted, one blood injury. I only mentioned the names of the accused Tarun Saso and Babul Changma in the Ezahar. Exhibit 1, I knew the names of the accused from the deceased before the Ezahar was lodged. This is a very important fact also.
Hmm?
He stated that he knew because he has already stated that the deceased had told him. And thereafter, the Ezahar was lodged only after the deceased expired. So now, in the Ezahar, if you lordship peruses the Ezahar, the names of only 3 of the appellants are there. He has not named other
Below mention accused and others.
and others. But even though in his as per his statement, he's saying that he knew the names of all the accused persons, and that before the lodging of the FIR. Bimal Puragohai was with. This is important because lordship
Has he been examined?
he has been and he has contradicted this statement.
PW?
Bimal Puragohai will be lordship PW 20 lodged
All right.
because he has contradicted this statement.
So that's, let us read the
Yes, yes.
evidences and then you make your submission one by one.
Bimal Puragohai was with me when I went to the hospital and talked to the deceased. Bimal is still alive. Later, police questioned me during the investigation. It is not a fact that I did not tell the police that deceased Nathu had told me the names of the accused persons who assaulted him. It is not a fact that I told the police about Tarun Changmai, Saso Changmai, Latu Changmai of village Charaguri, along with some others, took Nathu to Karigaon and admitted him into the hospital for his treatment. It is not a fact that I told the police the names of some Vishnu Saikya, Rontu Changmai, Diti Changmai. It is not a fact that Nathu did not tell me the name of any accused persons prior to his death. I did not witness the incident. It is a fact. It is not a fact that neither I mentioned in the Ezahar nor did I tell the police that I heard about the incident from my mother, Purnidoi. The distance between Loraputa and Karigaon by road is 6 kilometers, and across the field it is about 4 kilometers. It is a fact that I did not mention in the Ezahar as to where from I knew about the incident. I do not know accused Tarun Changma is blind. It is not a fact that I did not have a good relation with the deceased. The people of Loraputa do cultivation on the grazing lands and live there. The Darika River separates Loraputa from Naujan. It is not a fact that deceased Nathu Puragohai forcibly enters in the house of people of Loraputa, and when the women see him, they shut the door. It is not a fact when
What is this? What is this?
it is not a fact that the deceased Nathu Puragohai forcibly enters the house of the people of Loraputa. Nathu, that is the deceased lordship. Loraputa,
This is a suggestion made,
suggestion.
which he denied.
Yes, sir. And when the women see him, they shut the door.
Shut the door.
It is not a fact that when Nathu had committed untoward incident at the wedding of Nalia's daughter, the people present at the wedding kept him tied. It is not a fact that Nathu was tied and assaulted at Nalia's house at night and was released in the morning. The house of the accused persons, except the house of Saso, are situated at Karigaon. It is not a fact that the accused persons did not assault deceased Nathu Puragohai. I had not seen deceased Nathu at home on the day of occurrence. It is not a fact that the deceased did not reside in the house at all. A blood-stained shirt and blood-stained white vest were seized from the body of the deceased to exhibit 3M.
So what do you have to say about this witness?
About lordship,
PW1?
PW1. Lordship, what I have to actually say is that PW1 on various points have contradicted his statements, and especially those contradictions have been brought forward from other witnesses, including this stand lordship, where your lordship has inquired whether there is a suggestion to the effect that the deceased was having a ill treatment towards the other people in the village. That has been corroborated by even the defense witnesses who had stated that yes, during at the time this person Nathu, even prosecution witnesses have stated that he used to carry 2 dhows with him, and he used to be a habitual drunkard. Village meetings were conducted where he
Does
had.
that give any license to anyone
It
to
does
kill
not.
him?
Lordship, it does. It does not. That is true, but this was actually the whole case is of public
What is
outbreaks.
the injury? Mortem report say,
Head injury, hematoma caused by head. Lordship.
and blood in the head is seen.
Lordship.
But only stick was recovered, scissor list,
Only one bamboo stick.
bamboo
which
stick.
stayed. But no one has seen with the stick, or no one has seen any
And
assault.
what is the evidence of the doctor? Is it likely that the stick will cause that
It can.
injury or something else?
It can, the stick can cause death.
Yes, let's proceed.
Lordship. Next, Lordship, may come to page number 14. Let's be the position of PW2.
Yes, who is he?
The
She.
PW2 is a person who was present in that house where that Hokam was going on.
All right.
If I may, Lordship. I know accused Tarun Changmai, Saso Changmai, Pinku Changmai, alias Rajiv Changmai amongst the accused persons present in the court. I do not know the rest of the accused persons. I knew Nathu Buragohai. Nathu died after he was tied and taken away by some boys. He died about 3 years ago. I went to attend a hokam at Surat Saikya's house, and there I heard from the woman that the deceased Nathu was caught and taken away. I saw that the accused Saso, Ananta, Tarun, and Latu Changmai caught Nathu and took.
Sasu is petitioner number.
Saso is Lordship petitioner number. There is one Lordship. Because Saso alias Ananta
Ananta?
Changmai. Ananta is one Lordship, sorry. Ananta is one. Tarun Changmai is 5. Latu Changmai is 3.
And what about Sasu?
Saso will be in the other Lordship. Other matter.
These are in 179.
Lordship. The ones I have mentioned, Lordship, are in 179, Lordship. Saso is the alias name, Lordship.
Yes, APP. Sasu is petitioner number 1 or in the second? Just check. First title.
Ananta Changmai, Lordship. Known as that will be Lordship appellant number
Sorry, not petitioner. Appellant.
appellant.
Appellant 1 in.
Appellant 1.
In which matter?
There is once this Lordship, the 179.
No, in 179 you say Ananta,
Yes, Ananta is there. Ananta Changmai is there.
then Sasu.
Saso, Lordship, that is it's showing as Ananta only. Lordship.
Anyway, you verify this because these are important.
Yes, sir. Because as per the judgment, Lordship, that alias word is Saso alias Ananta Changmai.
Okay. Then
Yes, Your Lordship. Caught Nathu and took him away. Later, I came to know that Nathu died. Police questioned me. During cross-examination, Lordship, one has to go to our village crossing the river Darika and passing along the embankment. As one proceeds, first comes Kalia's house, Ethi's house, Prince's house, Hugain's house, Hadia's house, and our house, and then the forest consecutively. Thereafter comes the houses of Pinku, alias Sanjeev, and Tarun. Our houses are like farmhouse. It was holy on the day of occurrence. The Hokam was organized in the house of Nipet. We were chopping vegetables. There was Simolu tree near the embankment. I did not see from where the deceased Nathu was caught and taken away. About 10 to 12 people gathered in the house where the Hokam was organized. Nathu used to roam around in our area. Deceased Nathu used to carry 2 dogs. Nalia's house can be reached after crossing the river Darika. There was a marriage ceremony in Nalia's house the day before the incident. I do not know from where Nathu was taken. I have been to Karigaon. It takes 2 hours to reach Karigaon from our village. There is a forest apart our village and then comes a field. The field is not visible because of the forest. Lordship, at page 16 is the deposition of PW3. I know the 8 accused
so
persons.
from 2 only relevant is that she saw
She saw
a few of the accused
taking him away.
taking the
Deceased
deceased away.
Lordship.
That is only relevant,
Exactly, Lordship.
isn't it? Nothing else.
But again, she has contradicted saying that I do not know from where he has been taken away.
No, but that
Yeah.
is not relevant.
Sorry.
The last scene is with these persons,
With this person, Lordship. Yes.
correct?
Yes. But Lordship, if I may,
These are circumstances.
yes,
With
if I
one
may,
circumstance, you can always show
Right.
how the gaps are not the links are missing or whatever.
Lordship.
But this is one of the incriminating circumstances. Whether it is proved beyond reasonable doubt or not, that only we will find out after you read all the evidence.
Lordship.
Right?
Lordship.
How many witnesses are there?
Total 22 persons.
Mr. Bhuya, you are waiting for which matter? This matter will take some time. Yes.
Lordship, PW3 at page 16. Lordship. At page 16, the position of PW. I know the 8 accused persons present in the court. I knew this is Nathu Buragohai. The incident took place about 2 years ago. I was at home at the time of incident because there was my bodyguard's hokam in the house. Small kids were shouting that somebody caught Nathu.
So this is that Nipen Soikia's house where the hokam was going.
Nipen Soikia, Lordship. I came to the gateway and saw that the accused Ananda Changmai, Sanjeev alias Pinku, Latu Changmai, Okodi alias Ranjan Changmai, Jodumani Kaur, and some others were taking Nathu away. Thereafter, I came home.
One second. The
Okay.
names
Ananta Changmai,
Ananta Changmai is common. Sanjeev,
Sanjeev Changmai,
is it common?
yes, Lordship. Latu Changmai,
According to you have to give me these numbers.
the filling numbers. Lordship, that is
Ananta, I think, is one.
one, appellant one, then Ranjan 4, appellant number 2, Lordship.
Wait, Ranjan is
Appellant number 2,
and 179.
yes, Your Lordship.
Yes. Then
Then
Latu,
Latu Changmai is 3, appellant number 3, Lordship.
then Dadumoni,
Then Jodumani is Lordship will be from 169, Lordship. Jodumani is
All right.
appellant number 2 in 169.
one,
169.
and then Sanjeev,
Sanjeev is Lordship appellant number 2, even though it has been wrongly typed in the appeal as Sanjeev Changmai.
Sanjeev is two.
Two.
In one,
One is Ananda Changmai.
the 179.
179.
And Ananta Changmai.
Ananda Changmai is 1.
Yes.
Thereafter, I came home. The next day, I heard that Nathu had died. Later, police called me to the police station and questioned me. I gave my statement before the magistrate at Sibsagar. Exhibit 4 is my statement given before the magistrate. Exhibit 4.1 is my signature. During this cross-examination, Lordship, my house is situated at village Doraputa. Village Naojan is found just after crossing the Dalika River while coming from village Doraputa. One has to go across the field to reach Kumarpur, etc. from Naojan. The distance to Karigaon is about 7 to 8 kilometers by road. Houses of Kalia and Gethi and that of mine are situated near the embankment of our village. Then comes the houses of Hogen, Hatia, Padma, etc. And then comes the village. House of accused Pinku, Tarun and others are situated apart the jungle. There is jungle apart the river and Nalia's house is situated near the jungle. The field is not visible from our house. I saw deceased Nathu Buragohai being carried to the embankment, but I did not see him being taken to Karigaon. Nalia's house situated about 200 meters from my house.
Who
A
is
day-
Nalia?
Nalia is Lordship the brother, I think. Lordship.
There's a wedding.
Nalia is the wedding, the person whose wedding was there. Nalia's house situated about 200, where it is alleged Lordship that he had created the gun facility. Nalia's house is situated about 200 meters away from my house. A day before the incident, there was a Mulot Tel Dia, a ceremony usually performed on the previous day of the wedding ritual of marriage at Nalia's house. The house of deceased Nathu is at village Gorkuch, which is at a distance of 2.5 kilometers from our village. The embankment to which Nathu was taken is 200 feet away from our house. I recognize Nathu and the accused persons. I do not know all the people of Karigaon. Many people were arrested after Nathu's death. Vishnu, Ranjan, Hogen Saikia were among them. It is not a fact that I was tortured as regards what to say in the court. It is not a fact that when I made my statement as per the dictates of the police, they set me free and kept the rest detained. The day there was an annual hokam in our house. It is not a fact that I did not see the accused persons taking away Nathu Buragohai. Nathu died in the hospital. It is not a fact that people assaulted Nathu for creating nuisance, the marriage at Nalia's house, and owing to that, Nathu was lying in the field. And some people took him to the hospital, and that later he died in the hospital. It is a fact that the deceased Nathu lived in the house of Nijora. Deceased Nathu was a friend of Nijora's son Saso alias Ananta. That is the evidence number 1. Now, Lordship, at page 18,
So
Lordship,
even PW2 corroborates PW1 to the extent of
seeing
seeing the deceased
being
in
taken.
the company of these few of these accused persons, right?
Lordship.
Being taken away. Yes.
Now, PW4, Lordship, page 18. I know accused Saso alias Ananta Changmai.
Who is for?
PW4 is Pisitra Saikya, Lordship.
Who is she?
She was also there at in the house of Nalia. Basically, she was the body of that house.
All right.
I know accused Saso alias Ananta Changmai, Sanjeev and Tarun Changmai present in the court today. I do not know the rest of the accused person by appearance. I knew Nathu Buragohan. He died about 2 years ago. At a time of occurrence, there was a hokam organized in the name of my father-in-law. I was working at that function. Later, I
She's
heard
PW,
four words.
no, PW Sri's wife,
Nipin Saikya. Maybe Lordship.
right?
Lordship.
Okay.
There was a hokam in our house on the day of occurrence. There I came to know that the accused Saso alias Ananta, Pintu alias Sanjeev, Tarun, etc. got Nathu and took him away. The children were shouting. I came outside and saw a crowd of people. Later I came to know that Nathu died. So she has not seen or named anyone. Lordship. Our hokam was not a Hitor Pokia hokam, a spiritual ritual where rice beer is served as an offering. When I heard that Nathu was caught and taken away, the elders of our family were inside the house. I cannot say now which children had said so. Nalia's house is situated just apart the embankment of River Darika. I heard that Nathu was assaulted at the marriage of Nalia's house. Nathu died in the hospital. Nalia's house is 150 feet away from our house. Gethi's house is at the same distance from Nalia's house. Our house is situated at Gethi's house. Now we come home by under the Otenga elephant tree. Accused Tarun Sangma is blind.
Where are you reading?
Lordship, page 20 of the paper.
Page 20 is another person.
Oh, Lordship, sorry. So I jumped the page.
That's why I'm not. Why
Gotcha.
is it different?
Sorry. There was a pole bridge during his cross-examination. There was a pole bridge to cross the river Darika from Kalia's house. The pole bridge is about 200 meters from our house. Hokam was organized during the day hours at my father's in-law's house. My brother-in-law Nipin, Kalia, Simonto, and Hogan were in the house where the Hokam was organized. The Naojan field is not visible from our house. Subsequent to the death of Nathu Buragohan, all the people of our villages were called to the police station. Some of them were released from the police station and some of them were sent to jail. One can reach Nalia's house just after crossing River Darika. On the day of the Hokam, there was a Murot Tel Dia ritual in Nalia's house. I heard that there was a quarrel with Nathu in Nalia's house. It is not a fact that Nathu was assaulted and tied up at the wedding in Nalia's house. The people of Karigao do not have any agricultural field near our house.
No, nothing much.
Nothing
much.
substantial problems.
Yes.
Now, Lordship, at page 20, PW 5, Minu Saikya.
But she does say that she knows that some people have seen him being taken away.
That's hearsay, Lordship. These
But
things some
whatever,
small kids have told.
That is an attending fact which she
Yes, it's
confirmed that
corroborating that thing.
because she was there in the gathering.
She was there.
She has not seen it.
She has not. Now, Lordship, page 22, Lordship, deposition of PW 6.
So 5. What about 5 mini cycle?
5 minutes. 20.
Why are you jumping the pages?
Lordship, sorry.
Ask.
Sorry, Lordship. I know accused Ananda Changmai, Sanjeev Changmai, and Tarun Changmai were present in the court. I do not know the rest of the accused persons. I knew Nathu. Nathu died about 2 years ago. There was a hokam in the house of the day of occurrence. There I came to know that the accused Saso, alias Ananta, Pintu, alias Sanjeev, Tarun, etc. got caught and took him away. The children were shouting. I came outside and saw a crowd of people. Later I came to know that Nathu had died. Our hokam was not a Pitor Pokia hokam. When I heard that Nathu was caught and taken away, the elders of our family were inside the house. I cannot say now which children had said so. Nalia's house is situated just apart the embankment of the river Darika. I heard that Nathu was assaulted at the marriage of Nalia's house. Natu died in the hospital. Nalia's house is 150 feet away from our house. Getty's house is the same house distance from Nalia's house. Our house is situated at Getty's house. Now we come home by under the Otenga tree. Accused Tarun Sangma is blind. So Lordship hearing, as per her, again hearsay that she has come to know, she's not seen.
Arun Changma is
Blind.
appellant number.
Tarun Sangma will be Lordship,
Has the IO confirmed that he
Five.
is blind?
Five.
This is the second time the prosecution witness has said
yes, sir.
he is
No,
blind.
previously there was a
A suggestion that was
Now-
denied.
Yeah, now it's admitted.
Now this is which part it is said in the 5 stage, no?
5 says.
Okay.
Lordship. So, Lordship, page 22, Lordship, Sri Bhupen Saikya, that is deposition of PW6.
Yes.
I know all the accused persons present in the court. I know the deceased Nathu Buragohai. Nathu Buragohai is no more. The incident took place about 3 years back. The incident took place about 9:30 a.m. on the day of occurrence. I was taking blessings in the Hokam of Bordeta. I heard children shouting outside and Nathu was caught. I came outside and saw accused Saso alias Ananta and Pinku alias Sanjeev Changmai taking Nathu towards Kali. I got back
Since I was taking blessing, I heard children shouting outside that Nathu was caught. I
Lord.
came outside and saw
accused Ananta and Sanjeev Changmai
and so
taking Nathu
taking Nathu towards
towards Kali. I got back to my work. Next day, I heard that Nathu died at Simsagar Hospital. While giving my statement to the police, I told what I've said. During cross lordship, Kalia and Gathi were present in our Hokam. The Hokam was at Nipen's house, and Nipen was in the farmhouse. Accused Tarun Changmai was also there. Only I came to the outside. No one else came out leaving the Hokam. So lordship, here he's saying that Tarun Changmai was present inside and he did not. No one else came outside the Hokam. None but I had witnessed what had happened. There was a pole bridge on the river Darika near our house. Nothing beyond river Darika is visible from our house. The embankment of Darika is about 200 feet away from our house. I saw the backside of the accused persons and nothing. I did not see who was holding Nathu. I have said that Pinku and Sasu alias Ananta took Nathu away because the kids said so. I could not recognize both the accused from behind. The children who were shouting were about 5 to 7 years old. When I returned, Jolpan was being served to the devotees. I did not say anything to anyone inside. I did not see who went in which direction after crossing the embankment. The field of Karigao is not visible from our house. The house of deceased Nathu is about 4 kilometers away from our house. The house of Nalia is situated apart the embankment. I did not attend the marriage in Nalia's house. The next morning after the marriage, I heard that Nathu was assaulted at the marriage of Nalia's house, as he had created nuisance there. Nathu had friendship with accused Saso alias Ananta. That is the appellant number 1. It takes about one and a half hour to reach Karigao on foot from our house. So, Lordship, there is a statement here where he's saying that he was present in the Hokka and no one else witnessed. And he also saw the backside of the
and no one left.
yes, no one there.
And he had only seen two of the accused
Lordship,
taking.
back of 2 of them.
What are those appellant numbers?
The back of 2, that is Pinku. Alias
Tarun
versus-
Changmai is one.
Tarun Sharma is 1. Lordship.
No, that is sorry.
No,
he saw,
Tar-
sorry, Ananta. That is one.
1. And sir is 2. He has only seen
Sanjeev is two. 179.
Sanjeev Changmai. Yes, 2. Lordship.
He saw only two.
He saw only appellant 1 and 2.
Yes.
Lordship, now at page 24, the position of PW7.
Yes. One
know-
thing is consistent till here that one or two of the accused
Had taken.
had taken. That much till
That much
here
is-
appears to be consistent.
Lordship.
Yes.
I know accused Pinku Changmai, alias Sanjeev, Ananta Changmai, Latu Changmai, Ranjan Changmai, and Vikas Changmai present in the court. I know the rest of the accused only by face. I knew this is Nathu. Nathu died about 4 years ago in Sagar Hospital due to the assault caused by some persons. I was at the Hokam of Nipen's father and my bodita. When I was going down to seek blessings, a hue and cry was raised. I came out and saw a crowd near the embankment of the river. I saw that accused Sanjeev, Ananda, Latu, Ranjan, and Vikas were taking Nathu away by dragging and pushing him. I saw the incident from 200 feet away.
Actually, now Sanjeev is number 2,
Sanjeev is
Ananta is number 1,
Lordship,
Latu is
3 Lordship,
3, and Ranjan
4 in 179 Lordship.
Yes.
I saw the incident from 200 feet away. At that time, it was around 10:30 a.m. Thereafter, I came inside. Other people also came out and saw the incident. I saw Nathu being taken towards Karigaon. Police questioned me. I made my statement before the magistrate in the court. Exhibit 5 is my statement made before the magistrate, and Exhibit 5(1) is my signature.
Mr. Das, when you next time when you prepare and you read your evidences, these numbers and PWs is very essential. You mark it. I remember I had seen Mr. Chaudhary, senior counsel, always used to argue in this manner, Jake Praveen Chaudhary. I'm sure Mr. Punya would agree to that. Also. That's how I learned, sitting in court, seeing Mr. Chaudhary arguing a criminal appeal. So, because you see, that helps. When it's either a witness or the accused, you just say the number. It helps. Yes.
I had said the things before the magistrate, what I have said today. During cross-examination, Lordship, I am Nipen's cousin, son of the youngest brother of Nipen's father. Some women and I came out from the house where the Hokam was going on. I saw the accused persons and Nathu from behind near the embankment. Having seen the accused persons from behind, I have stated that I know them. I did not see the accused persons assaulting Nathu when they were taking Nathu away. Nothing is visible from our house beyond the embankment of the river. When I came inside, I saw the devotees were having jalpan. I told the people that Nathu was caught and taken away, but I did not tell who took him away. It is not a fact that I have said the names of the accused persons because the children have uttered their names. It is not a fact that I did not see the accused persons taking Nathu away. When police called us, we about 15 to 20 persons, both male and female, came there. It is not a fact that I did not tell the magistrate that I had seen Nathu near the embankment when he was being taken away. My Bodota's Hokam was on the day on which there was a wedding at Nalia's house. Witness Bhugen was distributing curd and jalpan at the Hokam. It is not a fact that I did not see the accused persons whose names I have mentioned taking Nathu away. I saw about 40 to 45 people when Nathu was being taken. Some unknown persons were there. Now, Lordship, at page 26, deposition of PW8. I know all the accused persons present in the court. I knew deceased Nathu Buragohain. I came to know that Nathu was killed. On the day of occurrence, while I was taking blessings by bowing down at the Hokam in Nipen's house, I came out upon hearing a scream. I saw some women. The children told me that Nathu had been caught and taken away. Then I saw accused Saso alias Ananda Changmai, Sanjeev Changmai, Ranjan Changmai, Vikas Changmai, and Babu Changmai dragging Nathu away. Lordship, herein
Saso is
evidence
1.
number 3, Babu Changmai of 169.
Sasho is 1.
Saso is 1, Lordship, Ananda Changmai. Sanjeev
Pink
Changmai
is 2.
2,
Latu is 5 or
Latu is 3, Lordship.
3. And Ranjan is
Ranjan is 4,
4.
Lordship.
Vikas is
Vikas Changmai is appellant number 1 in 169.
and Babu.
And Ladu, Lordship,
No, Babu.
Babu is 3, Lordship, in 160.
Yes.
Dragging Nathu away. I saw them reaching the road by crossing the embankment of the abandoned channel of River Darika and taking him towards Karigaon. Thereafter, I came to the Hokam. Later, Nathu died in Sibsagar Hospital. Police recorded my
So
statement.
he for the first time says dragging.
Lordship.
Till here, I don't think anyone said dragging, the word dragging.
No,
Took away,
We're
they
taking
were
away.
saying taken away and all that. Now it's dragging.
right. Thereafter, I came to Hokam. Later, Nathu died in Sibsagar Hospital. Police recorded my statement. I made my statement before the magistrate in court. Exhibit 6 is the statement, and 6-1 is my signature. During cross-examination, Lordship, I saw that around 10 to 15 people surrounded deceased Nathu, and they were dragging him. And accused persons whose name I've mentioned were among them.
And it's very funny. I mean, he says he saw them dragging. He comes back to the Hokam and he doesn't alarm anyone. Yes.
Because maybe that is the case which defense was trying to make out, considering the character of the case. Basically, that's maybe the one. I
Yes.
saw that around 10 to 12 people surrounded Mrs. Nathu and they were dragging him, and the accused persons whose name I have mentioned were among them. I saw the faces of some and the backs of some others. I did not see the accused persons assaulting Nathu. When I came out, witness Bhugen, Talia, Nipin, etc. were sitting at the Hokam. It takes about 1 hour to Karigaon from the embankment on foot. I do not know where the accused persons who came with Nathu had gone after I had seen them. It takes around 2 hours to go from our house to Karigaon by the main road. I do not know from where the deceased Nathu and the accused persons were coming. Nothing can be seen from our house beyond the embankment. The house of Putul Borua, Anil Borua, Nalia Borua are situated apart the embankment. A day before the incident, there was a Murot Tendia ritual of marriage. I do not know who actually killed Nathu Buraga. I did not recognize all the persons who were taking Nathu away, as some of them were from another village. The women present in the Hokam learned from the children that Nathu had been taken away. It is not a fact that it is false that the accused persons whose name I have mentioned had taken Nathu away. Police called me. It is not a fact that I stated the things which were tutored by police before the magistrate.
The children, none of the children has been examined.
No. Now, deposition of PW9 the page 23. I know accused Tarun Changmai and Ananta Changmai among the accused persons present in the court. I heard the name of the deceased Nathu, but I never saw him. It's been almost 1 year since my marriage. The incident took place about 3 years ago. The incident caught a boy, the incident took place around 10 a.m. I was alone at home at that time. Some people caught a boy, brought him and tied him under a simolu tree, and then took him towards Kadigaon. I recognized accused Saso alias Ananda among the people who was taking the boy away. Some persons dealt a couple of blows to the boys with bamboo stick. I did not tell this to anyone. I was alone at home at that time. I came to know after a while the name of the boy was Nathu. I heard that Nathu died subsequently. Police recorded my statement. During cross-examination, Lordship, to go to my house, one has to go about 50 feet across the sand after crossing the embankment of
So
River
this
Dari.
is the house where he was brought.
No, no. He's just a witness who saw them taking away. That's what he stated. To go to my house, one has to go
I
about
was alone at home and
Yes.
that time some people caught a boy, brought him and tied him under a tree. I recognized so and so who was taking the boy away. Some person dealt a couple of blows to the boy with bamboo stick. This bamboo stick is what has been recovered already.
recovered.
That accounting of the blow appears to be convincing as far as PW9 at till this stage. Yes.
To go to my house, one has to go about 50 feet across the sand. After crossing the embankment of River Darika, there are Otenga and other trees alongside the road leading to our house. The Simolu tree I have mentioned is about 150 cubits away from the embankment of the River Darika. I could not recognize the boys who chased Nathu. Now, here in Lordship, they're saying they are chasing. The houses of Anil Borwa and Nalia are near our house. The field becomes visible only after crossing their houses.
So the question which she answered.
Right.
I could not recognize the boys who chased me. The question
Right.
which she's answered.
Yes, that's what. But I'm
It's in the cross.
Yes. But at one point he's saying that they will
They brought and tied.
die, and then
Now-
now they're chasing.
You see, in cross, these are questions, right? But the question must have, did you see the accused chasing? And she said, I could not remember the boy who chased.
But
You
in a
don't
way,
know.
what comes to the-
That is how,
But-
anyway,
the house, sorry. The lower part of the simulatory is not visible from our house. The roof of the house of Talia, Nipin, etc. are visible from our house, but the movement of people is not visible. I saw about 9 people chasing Nathu and tying him up. I did not see amongst them who amongst them killed Nathu. At that time, I was a bride. New
one
bride.
second, this again says, the field becomes visible only after the field is not visible from our proper to being yes, the roof. Saw about 9 people chasing and tying him up.
And tying.
He has clarified. He has clarified. I did not see who among them killed him. At that time, I was new bride. I was inside the house. The gift was about so and so.
It's about 100 people.
Yes, please wait, please wait.
It's the fact that I stated in a statement made before the police that a boy chased Nathu Burago, a resident of village Gorpush, and felled him to the ground by dealing repeated blows to his head by means of lathi. At that time, I did not recognize the boys of that locality. Now, Lordship, this particular boy has not been named. Who was I did not see Nathu kept tied near the simul. I did not see Nathu kept tied near the simul. I did not see from where Nathu was chased. I saw some boys taking Nathu away by the front of my house. I did not see Nathu being assaulted at that time.
Hmm.
I do not know where they were taking Nathu and why. I do not know the people of Karigaon. I did not attend the Murot Teldia ritual at Karia's house. I did not see accused Saso alias Ananta making assault.
She now says she did not see the assault.
Yes.
And earlier she said she
They
saw some person.
Some
There's a
person
couple of
taking the ball. I did not recognize the other people accompanying Sasu alias
Please check the vernacular also, right? From the record, the cross part. Yes.
Accused Saso alias Ananta was a friend of deceased Nathu. I do not know how Nathu died. My Lordship, at page 30, deposition of PW 10, Mr. Ananda Gogol. I know all the accused person in the court. The incident took place about 3 years ago. I was attending Akhand Bhagavat at Kilikaguri on the day of occurrence. I came back home in the evening. When I
A
reached
lot
home-
of ceremonies appears to be going on that day. Huh?
Yes. When I reached home, I came to know that someone had tied a boy named Nathu to a bamboo tree in front of our house. Later, I heard that the accused person had tied him. Lordship, a hearsay witness. Later, I heard that the police took Nathu to the hospital and that Nathu died. I did not see these incidents. The deceased Nathu was my nephew. It is a fact that I did not state to the police that the accused person had tied the deceased to a bamboo tree and that I saw bloodstains on the bamboo tree because the police did not ask me about this. Now, Lordship, PW 11, Lordship, Robin Khanibai, at page 31. On oath, among the accused persons present in the dock, I know accused Tarun Changmai, Ananta Changmai, Sanjeev Changmai. I know the rest of the accused persons by face, but I do not know their names. I knew this is Nathu Buragohain. Nathu was killed by some people around 4 years ago. Around 9:30 a.m. on the day of occurrence, when I was carrying milk, was coming home, I saw accused Sanjeev, Ananta, and some 10-12 youths making Nathu Buragohai walk towards Karigaon. I learned the following day that Nathu had died in the hospital. I told these things before the police. During cross-examination, deceased Nathu was accused Ananta's friend. I saw Nathu going on foot with the 2 accused persons and some 10-12 other persons. I went to Darika across Lora Puta.
This Sanjeev and Ananta seems to be common.
Common things.
Ananta is 1 and Sanjeev is 2.
Now, Lordship, page 33, that is deposition of PW 12. Among the accused persons present in the dock, I know the accused Aponi, alias Ranjan Changmai, Latu Changmai, Sanjeev Changmai, and Ananta Changmai. I know the rest of the accused persons by face, but I do not know their names. This is Nathu Buragohai was my younger brother. Nathu was killed some 3 years ago. On the day of occurrence, I went alone to a jungle to bring firewood. I reached home in the afternoon. My mother, Punidoi Buragohai, told me that Chandra had told her that someone had apprehended and tied Nathu up, and that thereafter they had taken Nathu away. I waited for Chandra Kokai, and he told me
Is
that
it PW1?
but- and he told me that some people had apprehended Nathu and tied him up, and that they had taken him away. In search of him, Chandra, Bimal, and I went to Karigaon. Chandra said that Nathu had been taken away in a vehicle. We found Nathu in Sibsagar Civil Hospital. I saw blood all over Nathu's body and his finger cut. I came to know after questioning Nathu that accused Pinku alias Sanjeev, Oponi alias Ranjan, Latu Changmai, and Saso alias Anant Changmai had assaulted Nathu. Then I felt dizzy and fell down. Thereafter, I was waiting near Nathu at the hospital. Nathu died at 9 a.m. in the following day. My elder brother Chandra, during cross examination, my elder brother Chandra, my mother and I stay separately. Nathu always stay with us in our house. It is not a fact that deceased Nathu did not stay with us. Karigaon is about 7 kilometers away from the village. There are villages alongside the fields. I reached the hospital before evening. It is not a fact that I did not tell the police that I had gone to the hospital and that I have been there till Nathu's death. It is not a fact that I did not go to the hospital. I am unaware who till date who admitted Nathu into the hospital. I do not remember what time of night Nathu cited as a time of making assault to him by the accused person. When deceased Nathu told my brother Chandra the names of the people who had assaulted him, I was at a distance of 12 feet away from them. The police took my statement the following day of Nathu's death. It is not a fact that I did not tell the police that when Nathu had told my elder brother Chandra that accused Latu, Ananta, Sanjeev, and Runjun had assaulted him, I heard it. I did not purchase any medicine at the hospital for Nathu's treatment. I do not know what is the distance from Golpush to Loraputa. It is not a fact that the deceased used to visit some places such as Naojan. It is not a fact that Nathu used to terrorize others. It is not a fact that I falsely stated that accused Sanjeev, Ranjan, Ananta, and Latu had assaulted Nathu. The evidence was, but here, with regard to the names being heard, there is a contradiction with PW1 because he stated only about 2 names. Now, Lordship, PW 13, page 35. I know all the accused persons present in the court. Their names are Ananda Changmai, Latu Changmai, Tarun Changmai, Sanjeev Changmai, Apani Changmai, Ranjan Changmai, Babu Changmai, Vikas Changmai, and Jaduman Changmai. I saw the deceased Nathu Buragohai only on the date of occurrence. Around 3.5 years ago, I saw deceased Nathu kept tied to a bamboo tree in front of the Hari Mandir of our village, Kumarpur, Karigaon. At that time, I was the government Gaon. It was the occasion of Holi. There is an agricultural field behind our house. People were running on the field. It was around 10 a.m. then. The neighboring people said that a youth was apprehended. Then I went along the road to see what had happened. I saw Nathu Buragohai's hands and legs were tied to a bamboo group near Namghar. I made a phone call to the police immediately. Soon the police reached the place. The police took Nathu Buragohai away by a police vehicle. Thereafter, I learned that police had taken Nathu to civil hospital. I did not see the persons who brought Nathu to that place and kept him tied. At that time, I saw Nathu. I saw accused Sanjeev Changmai and some other persons near me. At that time, when I saw Nathu, I saw accused Sanjeev Changmai and some other persons near me. I saw blood in Nathu Buragohai's head and legs. Later, the police came to me by showing me a list of the names of the accused person, asked me to show their house. Whereupon, I showed the police the house of the accused persons. The police and I did not find the accused persons in their house. I also showed the place of the occurrence to the police. Later, I came to know that Nathu Buragohai had died in the hospital. In cross-examination, now this is interesting, Lordship. I saw around 100 to 150 people on the field.
Exaggeration.
Besides Nathu, the police also took the rope with which Nathu was kept tied. It is not a fact that I did not see Nathu kept tied to a bamboo tree with a rope. At the time when Nathu was kept tied, some 250 people were nearby. I did not see anyone assaulting deceased Nathu. Nathu went to the
Numbers are increasing.
numbers. I did not see anyone assaulting deceased Nathu. Nathu went to the vehicle of the police on foot and then he boarded the vehicle. The police arrested some people randomly in connection with the incident. The police also arrested me. Later, I was released on bail. I showed the police the house of the accused person after I was enlarged on bail. I did not notice the injuries of the deceased Naku. It's not a fact that I did not tell the police that accused Sanjeev was standing near Naku. If one goes from my house to Raraputa across the field, the distance would be around 7 kilometers.
I think much has come except that he went after the incident is done, and when he reached the deceased was already tied to the
Right?
tree, and he had seen few people gathered. Out of the people that were gathered there, we saw two of the
Appellants.
appellants along with some more people. That is all.
Moreover, one more fact what can be seen that there was it was like a witch hunt it was like a witch hunt which happened. Basically, as you say, that a lot of people were arrested. I mean, police literally have taken everyone. And moreover, the fact that they were not present in the house to show an intent that they had a guilty intent. That's why they were responding to the house. That is again confirmed that he went and showed the police the houses only after he was enlarged. So maybe during that time they were also either maybe arrested or maybe they.
But still, we are halfway to the positions. But at least there are more than 3 witnesses
But
who have consistently said that they have seen the
1, 2, and 3.
Hmm?
Consistent names are 1, 2, and 3. Number 1, 2.
whatever. That's why I'm not naming
Yes, sir.
the names yet.
Yes, sir.
But I said few of the accused appellant being taking the deceased. So that much they have said. Now, whether it was by dragging or how that, of course, one person have tried to say dragging, the others have not. So that is different thing because it's now, and also the other witness who says she saw the accused dealing a blow. But in cross, she says he did not see. The only thing that is coming till now is the last
Last scene.
scene appears to be with
With
one
this
or
one.
two of your tenants. Yes.
Lordship, page 37, Lordship, is the examining doctor, Lordship. So on 8/3/2004, I was working as senior medical and health officer at Sibsagar Civil Hospital. On that day, I performed postmortem examination dead body of Nakura Gohai on police requisition in connection with Sibsagar PS 75 of 04 under section 302-34 IPC on being identified by Constable 310 Jogenpura and relative Chandrapura Gohai and Vimalpura Gohai as found as below. External appearance, Lordship, body pale, rigor mortis present, male body of average width. External wounds, lacerated wound under the middle of the joint of scalp, 2 inches long and stitched. Black eye, left eye, abrasion over chest, abrasion right middle finger, and great toe of the right foot. Cranium and spinal canal, hematoma over the joint of the scalp. Skull is fractured. Fracture of skull is fracture of skull bone, which is linear fracture extending from the joint to the right parietal bone. Subdural hematoma below the fracture site. All other organs are healthy. In my opinion, the cause of death due to syncope as a result of head injury. Exhibit 8 is the postmortem report. 8.1 is my signature. The signature of the then joint director of health services. The fracture injury might be caused by April Exhibit 3 lucky. That's the pathology. Now, injury
It
gross.
doesn't look like one person hitting it. Perhaps
Lordship, there might have been a
more than one.
Now, Lordship, during cross examinations, injury number 3 and 4 are superficial and simple. The injury number 1, lacerated wounds under the middle of the joint of the scalp, is fatal injury. Hematoma exerted pressure on the cerebral hemisphere. Formation of hematoma is a slow process. This kind of injury may be caused within 24 hours or more time.
Because that is, you see, it looks like only one weapon was used. That is actually. But so that is why that injury number 1 appears to be with the last.
So, blood collected in the hematoma, if extracted, then the pressure on cerebral hemisphere will be reduced. First flow with sufficient force may also cause. The
Yes.
Lordship says one single flow can also, first flow can also cause that. Deposition of PW15, Lordship. On oath, I have recognized the accused person present in the dock. I heard the name Natu. The incident took place 3 years ago. I went to Rajmai Bazaar that day. Returning to the village, I came to know the police had picked up a youth on the two-tire vehicle. Later, I learned that the person had died. There is nothing relevant.
Yes.
Now, PW 16 Lordship, page 40. I have recognized accused Saso alias Ananta and Pinku alias Sanjeev Changbai present in the court. I do not know the rest of the accused persons. I knew this is Nathu Gohai. He died some 2 years ago. I was at home at the time of occurrence. I heard a commotion when I was at home. When I heard a when I heard a commotion that the youth had been assaulted, I came out of home to see what happened. I saw some people. Later, I learned that Nathu had died at Karigaon. Accused Pinku alias Sanjeev, Saso alias Ananta, and some other people had apprehended Nathu and taken away. The village located across the stream is Loraputta. The village located on the other side of the stream is Naujan. Besides the Otenga orchard, there are 6 families in our locality. I do not know the names of the fields that one reaches after crossing Nalia's house. The field is not visible from our house. I do not come to a particular end. I did not come to a particular end of the field to see the incident of Nathu being apprehended and taken away. I heard that accused Saso and Pinku were with the people who had apprehended Nathu and taken the latter away. Nalia is my elder brother. At that time, when Nathu was apprehended and taken away, we had some guests in our house. I was at Nalia's house on the occasion of marriage ceremony. The people assaulted Nathu at Nalia's house and kept him tied there. It takes about half an hour to reach Nathu's house. If one goes on foot, at times, the deceased came to the village of Loraputta and spent the nights there. Now, here, it's cross-examination. One thing can be seen that he's saying that actually the alleged assault or him being tied was at the place of the wedding. Because it stated, I was at Nalia's house on the occasion of the marriage ceremony. The people assaulted Nathu at Nalia's house and kept him tied there. It takes, so Lordship, there can be another probability here that maybe they were taking him away, one being the friend of the deceased also, event number 1.
Okay.
Now, Lordship, page 42, Lordship, that's PW 17.
And somewhere I think it also came that he had misbehaved at the wedding.
Yes,
Somewhere I think that suggestion was put.
suggestions were given, Lordship. And later on, Lordship will find it the PW 17, Lordship, I have recognized accused Ananta Changmai and Sanjeev Changmai. I do not know the rest of the accused persons. I knew this is Nathu Gohai. Nathu was killed some 2 years ago. I was at home on the day of.
Your defense that there are 2 views possible. That is one of your defense.
Yes, sir. I knew this is Nathu Gohai. Nathu was killed some 2 years ago. I was at home on the day of occurrence. At the time of occurrence, when I was attending the Hokam held at Nipen's house, I saw Nathu Gohai being taken away by accused Ananta alias Saso, Sanjeev alias Pinku, and some other people. I saw Nathu being taken away towards Karigaon. During cross, my house is at village Loraputta. After crossing Darika, while going from my house, one reaches village Gorkush, Naujan, and many Outenga trees are there. There are house of 5 families apart those elephant apple fields. There is a field beyond the elephant apple orchard. The fields at the village Naujan Gorkush is not visible from our locality. It is not a fact that I did not see accused Ananda and Sanjeev apprehending Nathu and taking him away. I saw from a distance of about 1 furlong that Nathu was being taken towards the south. I recognized Ananda and Sanjeev from behind. I could not recognize the people who were with those 2 accused persons. This is Nathu went on foot. This is Nathu was a friend of accused Ananda. I do not know who took Nathu away after apprehending him. It is not a fact that I did not recognize accused Ananda and Sanjeev. It is not a fact that I did not see Nathu being apprehended and taken away. Now, Lordship, PW 18. I know accused Saso alias Ananta Changmai by name and face. I do not know the rest of the accused persons present there. This is Nathu Gohai was my uncle's son. Someone killed Nathu some 3 years ago, that is in the year 2004. On a day, Nathu's dead body was brought to our house, and a short while later, the police arrived there. The police took me to the place of occurrence. The place of occurrence is at village Loraputta. The police found a lathi under a simalu tree and seized the same. Metal exhibit 3 is the said lathi. In cross-examination, material exhibit 3 is similar to a post. Our people use post and stick for herding cattle. The police seized the lathi from under a simalu tree on the raised bed of soil, used as seed bed in the unintelligible lordship, field. If one comes 1 kilometer across the field from the place where the lathi was found lying, he will reach Kari.
Yes.
Now, Lordship, PW 19, Lordship, page 46. On note, I know accused Tarun Sangma was present in the court. I do not know the rest of the accused person.
It is relevant.
No, Lordship, because he has no knowledge.
20.
Lordship.
20 is the person who was in the hospital.
Yes, along with the PW 1. On note, I have recognized all the accused persons present here. This is Nathu Buragohai, was the son of my uncle. Nathu Buragohai was killed in the year 2004, but I did not witness who killed him. When I was in a hotel situated 2 kilometers away from my house, Nathu's elder brother Chandra Dilip came there and told me that Nathu was kept tied in Karigaon. After sending them, when I went there later, I met them near Kumarpur High School, and then I learned that the police had taken Nathu to Sibsagar PS. I came to the PS and I was told in the PS that Nathu had been admitted into Sibsagar Hospital. Going to the Sibsagar Hospital, I found Nathu there. I found Nathu in an injured condition. Injured Nathu told Chandra Buragohai that Saso alias Ananta and Pinku alias Sanjeev Changmai had been. He has stated only 2 names.
That is all right, but he has supported this.
He has supported logic, but there is a contradiction between the names.
Contradiction is about the name.
Yes, sir.
He may have forgotten the name also. But he has this part is what were the names PW1 have said?
Lordship.
PW1 have said
he-
numbers.
He told about Sanjeev Changmai Lordship.
Number 2.
Number 2. Then appellant number 1, Ananta Changmai. Then
And
Lordship Tarun Changmai. That is that is Lordship appellant number 5.
Yeah.
And he told about basically all the appellants Lordship.
All the
Changmai,
now
Vikas
this
Changmai.
person tells
Only-
about 2.
only 2.
Ananta is 1
1.
and Sanjeev is 2.
Yes. About
Correct.
Okay.
So that is why I'm saying he has corroborated PW1 to that part,
Yeah.
where PW1 said that when he had gone to the hospital and PW20 was with him, when upon being asked, his brother, the deceased, have said that so and so has beaten him. Okay.
I heard that.
Now,
but
you see, contradiction and omission. It has to be, every omission may not be a contradiction.
but he-
Here, he has not said a few names, but the fact that he has said this, undoubtedly will be a weak piece of evidence, but I'm just trying to, because the rest of the facts will also come, but isn't it? Unless he has clarified in his cross that no, only 2 names were said and not more than 2. Then that part and PW1 part cannot stand together, because then there is a difference. But merely because he did not say anybody, he didn't refer to more than 2, doesn't mean, this is my view, prima facie. That's why I'm expressing it with you, so that you can react.
he has actually stated, if your lordship follows the next slide,
All right.
I heard that much only.
That's what he heard.
Yes.
He may have just heard only 2 names. The rest he may not have heard.
I heard that much only.
But anyway, even that would be 2 views. Doubt perhaps is building up.
Nathu Buragohai died the following day. The police held inquest on the dead body of Nathu at Sibsagar Hospital itself, and I put my signature in the inquest report. Exhibit 2 is the inquest report. Exhibit 2 is the signature of the witness. In the hospital itself, a blood-stained check shirt and blood-stained white vest, which Nathu was clad in, were seized. Exhibit 3.2 is my signature as a witness in Exhibit 3, the scissor list. Material Exhibit 1 is the same, sir. During cross lordship, I went to the hospital twice. On the first occasion, I reached the hospital at 3:30 p.m. On the next occasion, I reached the hospital at 6 a.m. Nathu told about the accused. On the very first day, I visited him in the hospital. Just when Nathu told about accused Sasu and Pinku, I went to bring clothes.
See, he's clarified.
Sorry.
He clarified in his cross.
When Nathu told it to Chandra, nurse was present there. The following day, when I met Nathu in the hospital, he was not in a condition to speak. The police went to see Nathu the following day. I never made a statement for the police. It is not a fact that I did not go to the hospital on the first day, the day Nathu was admitted into the hospital. It is not a fact that Nathu did not say anything to Chandra or me. Though I learned from Nathu that accused Saso alias Ananda and Pinku alias Sanjeev had assaulted Nathu, I did not inform this intelligent. It is not a fact that when I went to the hospital only after learning about Nathu's death, it is not a fact that I've come to the court for the first time today and used this fabricated evidence. It is not a fact that Chandra Buragohai and I went to the hospital only after Nathu's death. Now, Lordship, PW 2021, Lordship.
How
The
many are there?
total 22, 23, Lordship. PW.
21.
PW 21. On note, the 8 accused persons present in the court belong to my village, but I do not know them. I did not know this is Nathu Buragohai. The incident took place 3 years
He
ago.
came to know from his wife.
He came to know.
Nothing much.
Yes, sir.
Yes, PW 22.
Now, Lordship,
He is the IO.
Lordship, Ranjit Kumar Borra, yes, Lordship. He was the
IO.
Mr. I was transferred, so he was the
Achha.
person with the charge sheet, Lordship.
He is the one who
Submitted the
submitted the charge sheet.
On 36/2005, I was on duty at SI at Srinagar PS. That day, the officer in charge of the PS entrusted me with the task of completing the remaining part of the investigation of Srinagar PS so since the predecessor IO, Gurudev Singh, had already been transferred. On perusal of the case diary, I found that the predecessor IO had completed the investigation and only the charge sheet remained to be submitted. I submitted a charge sheet against accused Dadumani Kumar, Babu Changmai, Ananda Changmai, Sanjeev Changmai, Latu Changmai, Ranjan Changmai, Vikas Changmai, and Tarun Changmai for committing an offence under 147, 148, 149, 341, 342, 302 IPC. Exhibit 10 is the charge sheet. Exhibit 10(1) is my signature. The investigating officer sees one bamboo lathi in connection with the case. But also Exhibit 23, this is the IO. I know the accused person in the block. I know absent accused Babu Changmai alias Chandan. On 8 March 2004, I was on duty as an SI at Srinagar PS. That day, the officer in charge of the PS received an Ezahar at 11:50 a.m. from the informant Sri Chandra Buragohai and thereafter registered the Srinagar PS case 755/04 dated 8 March 2004. Exhibit 1 is the said Ezahar. Exhibit 1-2 is the signature of the officer in charge, Pradeep Buragohai, with a note. The officer in charge interested me with the charge of the investigation. In the course of the investigation, I first went to Srinagar Hospital, Joysagar, and prepared inquest report on the dead body of the deceased, Nathu Buragohai, as per the provisions of 174 of the CRPC, in presence of the witnesses. Exhibit 2 is the inquest report. Exhibit 2-3 is my signature. I saw that the upper portion of the left eye of the deceased had turned black. I saw cut in the right index finger. I also saw injury on his right thumb, knee, chest, back, and head. After preparation of the inquest report, I sent the dead body for postmortem examination. Exhibit 11 is the dead body, Chalan, and Exhibit 11(1) is my signature. At the time of holding inquest, I seized a bloodstained shirt with a small checks and a bloodstained vest from the dead body. Exhibit 3 is the Caesar list. Exhibit 3-3 is my signature. Material Exhibit 1 is the said bloodstained shirt, and material Exhibit 2 is the said bloodstained vest, which I have seen in the court today. Thereafter, I, along with the officer in charge, went to the village Panbecha book. I inspected the place of occurrence as shown by the informant and other witnesses. The place of occurrence is an open field at the village Panbecha, around 2 kilometers away in the south of the house of the informant Chandra Buragohai, and this is Nathu. I drew a sketch map of the place of occurrence. Exhibit 12 is the said sketch map. 12(1) is my signature. Thereafter, I recorded the statements of the witnesses present in the occurrence. Finding a bamboo post at the place of the occurrence, I seized the same. To Exhibit 9, Caesar list. Exhibit 9(2) is my signature. Exhibit 3 is the said bamboo post or lucky. I learned from the witnesses that some 10 to 12 youths had assaulted deceased Nathu Buragohai and took him to Karigaon from village Loraputta. So I went across the field of Karigaon about 4 kilometers away. Examining the witnesses at Karigaon, I came to know that Buragohai had been assaulted and that thereafter he was kept tied to the bamboo tree situated besides the road near the Namgar at Karigaon. I learned that Tarun Changmai, Pinku Changmai, Saso alias Saso Changmai, Ladu Changmai, Jadumani Kuar, Shiva Singh Kuar, Oponi Changmai, Lontu Changmai, Diti Gogo, and Babu Changmai had committed the incident. In this connection, I went to the house of the aforementioned persons, but all of them were absconding at that time. I recorded the statements of the eyewitnesses to the incident, namely Simonto Soikia, Bhupen Soikia, Kalia Soikia, and Nipen Soikia, under 164 CLPs. Later, I arrested the accused persons. Meanwhile, an order from a transfer was issued, and so I handed the case diary over to the officer in charge. It was learned in the course of the investigation that the names of Pinku Changmai, Oponi Changmai, Dodumoni Changmai, Babu Changmai, Ananda Changmai, and Ladu Changmai are Sanjeev Changmai, Ranjan Changmai, Geet, Govinda, Chandan, Sasu, and Latu respectively. I did not draw a sketch map of the place of occurrence at Karigaon, but I recorded all the details. In the course of the investigation, I seized blood-stained sheet scar of bamboo from the place of occurrence at Karigaon. During cross-lordship, the incident took place about 10 a.m. on 17/3/2004. The Ezahar was received at 11:50 a.m. on 8/3/2004. I recorded the statement of the informant Chandra Buragohai on 8/3/2004. It has been mentioned in the Ezahar that the incident took place at 10 a.m. on 7/5/2004 and that Nathu Buragohai died on 9:30 a.m. on 8/5/2004. It has been mentioned in the Ezahar that Tarun Changmai, Sasu Changmai, and Latu Changmai committed the incident. The informant has not mentioned anything in the Ezahar and in his statements as to where from he learned about the incident. Vipul Saikia, the village headman of Karigaon, first informed the PS of the occurrence on 7/5/2004. And thereafter, the police party brought Nathu Buragohai in an injured state from Karigaon and got him
No
admitted.
rope was seized, no? This
No
is the list.
Rope was not seized. Vipul Saikia, the village headman of Karigaon, first informed the PS of the occurrence on 7/4, and thereafter the police party brought Nathu Buragohai in an injured state from Karigaon and got him admitted into Sibsagar Civil Hospital for treatment. I neither made DD entry nor seized anything, nor mentioned anything about it, as it was the duty of the officer in charge before I was entrusted with the charge of the investigation. I did not seize any document relating to the injury sustained by the victim or any document of his medical treatment. So I'm not aware of in what condition Nathu Buragohai was admitted into the hospital. I also did not record the statement of the doctor in this regard. At a time of holding inquest on the dead body, it seemed to me that all the injuries sustained by the deceased were grievous in nature. I sent a copy of the inquest report along with the dead body challan. It is not a fact that except the injuries sustained on the head, all the injuries were simple in nature. I did not conduct any investigation to find out the relation between the blood-stained shirt and the lathi. Though there was no specific evidence to suggest that it was the seized lathi which was used in the incident, it was revealed in the statement of the witnesses that the lathi was used in the incident. Accordingly, I seized the lathi in the presence of witnesses. On perusal of the sketch map of the place of occurrence, that is Exhibit 12, I have become certain that the place of occurrence under a simolu tree on an open field, which one can reach after crossing the river Darika. The house of the accused is at village Doraputa, and the village is adjacent to the place of occurrence. However, the same has not been shown in the sketch map. The house of Kalia Saikia, Nipin Saikia, Padma Saikia, and Pipil Saikia have been shown in the sketch map. The house of Kalia Saikia and that of Nipin Saikia are situated on one side of the place of occurrence, but distance between the houses has not been mentioned. It is not a fact that distance between the houses of Kalia Saikia and Nipin Saikia is about half a kilometer. I drew Exhibit 12 sketch map on being shown to me by the informant and the witnesses, but I did not record the statements of these witnesses in this connection. It is not a fact that Exhibit 12 is a sketch map of the place of occurrence is not legally acceptable. It is not a fact that residents of 9 families are situated only at a distance of about half a kilometer from the place of occurrence. It has also been shown in Exhibit 12 that the houses of Padma Saikia and Pipil Saikia can be reached after crossing Darika Dam. It is not a fact that one can also reach the house of a person by the name of Nalia after crossing Darika Dam. The distance of the place of occurrence, that is village Gorapush, from the house of the deceased is about 2 kilometers. It has been mentioned in the statements of the witnesses under 164 CRPC as to how Nathu Buragohai had gone to Karigaon from the place of occurrence or how he was taken to Karigaon from the place of occurrence. Nathu Buragohai was apprehended and made to go on foot. When I reached the place of occurrence, I did not find water there. I did not seize the rope used in the occurrence. It is not a fact that I did not seize any weapon from the possession of the accused person and that no witnesses told me about the same. I did not get any specific evidence as to which accused person had dealt blow the head of the deceased as it was an incident of mob attack. It is not a fact that without having any incriminating material, I arrested people randomly in connection with the incident. I did not get to know the name of the person who had tied the deceased to a bamboo tree at Karigaon. It is not a fact that accused persons are not involved in the incident. It is not a fact that no one tied the deceased to bamboo at Karigaon. It is not a fact that I did not conduct the investigation properly. It is not a fact that the deceased misbehaved The deceased behaved with some women obscenely on the marriage ceremony held in the house of Nalia Purva, a resident of village Doraputa on 6 Street, 2004. Therefore, the public present there.
anyone who was present at Nalia's house during the wedding, anyone examined?
No, Lord.
No one examined.
No one.
Except Nalia. Nalia was examined. Right.
But he has stated not about any. He has not stated about any incidents. Then. It is not a fact that this is behaved with some women obscenely on the marriage ceremony held in the house of Nalia Purva, resident of village Doraputa on 6 2004, and that therefore the public present there assaulted him, as a result of which he sustained injury. And thereafter, when certain unknown persons found him lying injured in the field of village
But one of the
Doraputa,
prosecution witness have said, right, that he was first apprehended at Nalia's house.
yes,
What
most of
was
the-
that? Just read that part of the evidence. One.
Lord. I heard it was a hearsay basically, PW6. I heard that Nathu was assaulted at the marriage in Nalia's house as he had created
All right.
nuisance.
That is also can be right. No one has said about anything
In the marriage.
in the marriage. Yes.
Gotcha.
Any defense witnesses examined?
Yeah,
They are villagers.
villages.
They say about this,
They will say about his nature and character basically. But
but not about the
yes.
incident alleged to
No.
have had.
they had stated that he had this habit of mistreating women and all this.
You see, because for this court even to take that, there has to be something more.
Gotcha.
Just because this has been constantly being suggested, may not be sufficient for this court to
Gotcha.
take another view in the matter. And that, as I said, that is also not giving anyone a license to beat someone
Gotcha.
that fashion. Yes, you complete this.
Gotcha. It is not a fact that I made those people as accused who saw the deceased in an injured condition, and that even though the village headman gave the specific details of the incident to the police at the BS, I did not make a GD entry to that effect. And the fact was kept a secret. It is not a fact that as village headman Vipul Saikia was arrested and forwarded to the court, he was in jail. While making statement before me, witness Chandra Buragohai did not say that deceased Nathu had told him the names of the people who had assaulted the lady. While making statement before me, witness Chandra Buragohai said that Tarun Changmai, Saso Changmai, Latu Changmai with some other persons apprehended Nathu and took him to Karigaon, and that Nathu was admitted in the hospital for treatment. While making statement before me, witness Chandra Buragohai did not say that he had learned about the incident from his mother Punidoy Buragohai. While making statement before me, witness Sonmani Borwa said that Nathu Buragohai, a resident of village Warpush, was chased and that a youth had dealt blow to his head. While making statement before me, witness Dilip Buragohai did not say that he heard Nathu telling his elder brother Chandra Buragohai that accused Latu, Ananta, Sanjeev and Ranjan had assaulted Nathu. While making statement before me, witness Vipul Saikia did not say that accused Sanjeev was standing near Nathu at the place of occurrence at the time of occurrence of Kali. But this is an important aspect because the statements were not given for the police with regard to the deceased revealing the names of the person assaulting him. That was never done.
Sorry.
The statement that the deceased had been revealing the names of the appellants here. At the time he was in the hospital before Chandra Purva and the other person. But if here they have never stated before the high.
No, but PW1 in his 161 have not said.
No, that's what they stated.
Have you checked that in 161?
But I think it's a copy of the 161.
Please have a look. And 164 is also there.
164 is also
PW1 164 is there.
the P1 164 is not there.
Not there. Check in his 161. Whether he have said that when he had gone to the hospital and asked his PCR. Yes,
PW 24. On 15/3/2004, I was working as
that is judicial magistrate.
judicial magistrate, second
Nothing
class.
much, I don't think.
Nothing much. Now, Lordship, we come to the defense witness.
Before DW,
Before
one, where is your
P13 statement, Lordship.
313, any explanation anywhere by
Lordship,
anyone?
no, Lordship, they have denied everything.
Simple denial.
Simple denial, I don't know. And I'm not, I'm standing.
Yes,
Now, Lordship, deposition of BW1.
yes.
I know accused Saso, Tarun, and Pinku present here. I do not know the other 5 accused persons. I know Saso, Tarun, and Pinku as they are residents of our village, Doraputa. I knew deceased Nathu Buragohai. The deceased hailed from the village Gorpush, situated at about 2-3 miles away from our village. Nathu was an alcoholic person. He used to roam and stay here and there after consuming alcohol. Nathu died. The incident took place in the year 2004 on the day of Holi. An abandoned channel of river Darika flows near our house, and there is a bamboo bridge to cross the river during the dry season. In the monsoon season, one has to cross the river by boat. Nalia's house is across the Darika's channel apart from our house. A day before Holi, there was a traditional Murot Teldia ritual at Nalia's house. My Pehi, Srimati Nikunja Gogoi, and I went to attend the ceremony. Many people gathered at the event. In the ceremony, Nathu came drunk and misbehaved with the women gathered there. Then the villagers assaulted him and with whatever they got. Then Nathu ran away. Nathu's character was not good. He used to misbehave with women when the male persons were not present at home. The distance of Kuarpur Karigaon from the house where the marriage ceremony took place is about 5 kilometers across the field and about 7 kilometers along the road. In the dry season, one has to go on foot, and in the rainy season, one has to go by boat. Around 9 a.m. the next day, I heard that some boys caught Nathu from under the Simolu tree and took him to the doctor. And then to hand him over to the police, I came to know they made Nathu walk. If we have to go to the town, we go across the field via Karigaon. The day after the incident, I heard from Papu New York that boys had taken Nathu away. There are many elephant apple and Shimolu trees in the village. I already knew Nathu. I am not aware of any extrajudicial trial conducted in the village in connection with Nathu's drinking alcohol and creating nuisance. Holi is celebrated in the Mount of Fagun. I do not know the name of Nalia's daughter whose marriage ceremony was held. I went to the function around 7 p.m. and came back around 10 to 11 p.m. Nalia's house is situated at 7 to 8 houses apart from our house. It is not a fact that I did not attend the marriage ceremony. It is not a fact that Nathu Buragohai neither attended the marriage ceremony nor did he misbehave. It is not a fact that local people did not assault Nathu. I only heard that Nathu used to torture women after drinking alcohol in the absence of the male members of the family, but I did not see. I do not know if the accused persons here assaulted Nathu. It is not a fact that I have adduced false evidence to defend Saso, Tarun, and Pinku as their fellow here.
Because then, page 62, the second paragraph. Read it again.
I only heard.
Many people gathered.
Yes, Lordship.
Page 62.
Right? Yes, Lordship. Many people carried at the event. In the ceremony, Nathu came drunk and misbehaved with the women gathered there. Then the villagers assaulted him with whatever they got. Then Nathu ran.
This part is appears to be a bit unbelievable because of the nature of injury. It was one head injury and the others are not grave, isn't it? Father injury. Now here it seems he was assaulted with whatever they got. But where are those?
That is there.
A little
But what has to be seen also, Lordship, that that injury, the result of that injury took time to have its impact. So even
one day.
one day, Lordship. And till that point of the disease going,
But the case is the head.
Lordship. Cases we had, Lordship. But the thing is that all along the two prosecution witnesses only, it is being coming out that he walked on foot and he went to the police. So it was not that he had been carried away because of the head injury.
We'll come to that aspect
Lord-
later.
Lordship.
That would be an alternative argument coming from you, where you might seek a conversion, correct?
Lordship.
But first and foremost, we have to see whether a case is made out or not. So, beyond reasonable doubt, isn't it? Because the principles of circumstantial evidence is all well settled. So, Once you finish any more DW,
And one more.
after that you give the incriminating circumstances and then leave your I'll just take a small break, 5 minutes.
Okay.
I can 12 minutes. I am otherwise I can do, but my mind is not working. My wife is working.
Okay. Item number?
Any day of the next week.
Item number?
12.
12. Oh. Have you informed the other side? Uh,
I know my sister is nice week. Yeah.
but
I
inform them because
highly informed.
it is not fair for
Yes.
the other side. There's
I
no
s- I
difficulty
asked-
for accommodating you, but please inform them.
I
Eight-
asked, but I
80 Sikdar is there. I am allowing it subject to if they have any difficulty. Hmm? Mr. A.R. Sikdar, Fiber, Learned Counsel for the appellant, admits that due to the medical emergency, medical emergency, yes, at his home, he has to leave. Accordingly, seeks accommodation there is allowed. Hmm? Yes, next week, well, later that evening. If the other side has some
I-
inconvenience on that date, then we will change it.
Fine.
Please inform them.
Fine.
Please inform them. Mr. Locker, if you know the respondent counsels, please inform them also because they should not be unnecessarily waiting for this matter. Yes, Mr. Das.
So, thereby the trial for the evidence will be recorded and judgment and order dated.
DW2,
Who is there? Who is there? He states that I knew acute,
but he does not account the assault.
no,
He
but he,
simply says that is why the man present in the wedding assaulted.
but also he says an important fact that is with regard to the last page for last part.
Yes.
On the wedding night, Nathun misbehaved with the women present at the wedding. That is what the men present in the wedding assaulted Nathun. Then the women came inside the house. The women of the village used to run away on seeing Nathun because Nathun's behavior was not good. In this cross-examination logic, Nathun never misbehaved with me. A meeting was held in the village regarding Nathun misbehaving with other women. The meeting was held in the village school. The meeting was held with regard to the matter of Nathun intending to assault my husband. Many people were present in the wedding. Talia's third daughter was getting married. Their house is near our house. It is not the fact that I did not go to the marriage. He's also alleging of some behavior. Now, Lordship, page 66 is defense witness 3 Lordship.
He doesn't say much.
Lordship. But he states about seeing 100 people gathered in the
Number will not make it. Some might say 100, some may say 300. That is not so much relevant.
Therefore, Lordship, the judgment is at page 145.
No, but first, what has come out from the evidences accordingly?
Lordship, what has come out is, first of all, Lordship, the prosecution could not prove that who was the person who had dealt with the proof. Even if there is one single proof, no witnesses ever stated saying that they've seen only one witness, and basically the judgment, there was a wrong finding to that effect, where they thought that PW9 only to say that there was a blow given. The run at 4 kilo went by the chief examination, but not go to the cross examination. Because there she had stated, I have not seen who has given the blow. Now, the mere presence because there has to be an act to that effect. Then only lordship.
What about the last scene? He has been seen with the company of few of the accused.
Lordship.
That part is very consistent.
That is consistent, but lordship, again, there are contradictions as to who were present. All along the prosecution case, they have not stated, they could not stay
But
strong.
one or two names are
Apart
common.
from one,
One or two are common.
yes, one or two are there, but apart from that, all the other appellants, their names are not, are coming and going like that. So there is another part. Another aspect of the story which has come out logically from the prosecution case is that there might be a second explanation to that event, whereby maybe he was assaulted at the wedding by people who no one knows who has assaulted, and then he was taken away. Thereafter, he was taken away from there.
Those two persons who have said about the assault not inspire because he says they have assaulted with whatever they've got. But it is not that kind of an assault that is discernible from the postmortem report.
But maybe there,
Postmortem only indicates one blow in the head by a
but there are
blunt
abrasions
weapon.
and other.
which corroborates the fact that a lathi was used, right? And that lathi was recovered from the place of occurrence. That is that tree,
But again,
Correct. not from Nadia's house.
But again, the fact that arises that prosecution witnesses have also written that is a place in a village, they all use bamboo sticks. And the presence of a
But,
bamboo stick does not,
There was
But-
blood also, it was said. Though it was not
they did
said.
not
I
find
think
blood.
what Ayush said.
no,
that
I said once.
He did not match the blood in the stick and the shirt. This, no.
So prosecution could not prove that. That is the,
So what are the materials on which the trial court has held the convict and the
Gotcha.
accused convict?
if I may come to that, because
Just pinpoint
Yes.
those,
main aspect of pinpoint. The logic may come at page 162, logic, first of all.
hmm,
Page 162.
just say it, just sum it up.
Yes. It states that PW9, Srimati Sunmoni Borwa, in her evidence is
That
stated
we have seen. She has said initially, but in cross she said
exactly,
she did not.
exactly. That is one fact, because that fact was taken into consideration by the
All right, that goes. Then,
Yes. Thereafter, Lordship,
see,
apart,
Mr. Das, you have to give a chart of the incriminating circumstances.
Lordship,
I'm not, of course, you cannot deny that these incriminating circumstances are there.
Right.
Now, whether these incriminating circumstances have been proved, whether the gaps have been properly explained, whether any links are missing, these will be your arguments, right? But first and foremost, you must give it by way of a chart showing that these are 1, 2, 3, 4 incriminating circumstances which comes out from the report against the offense. Right?
Right.
And then you make your.
Right.
Second, a chart also would be required where you indicate which witness has named him.
who are the evidence?
Correct.
Right.
Now, there will be two ways of looking at it. If suppose after going through all the evidence minutely, the court feels no, there is a doubt. Of course, the benefit will go to. Right? But suppose it appears that no, at least against one or two, there has been constantly something that they have taken. Whether that itself would be sufficient to hold that they are the person who had dealt those blow without any doubt of any without any hypothesis of any other person having done it. Correct. These are the three things I think you need to meet with. So we'll need you'll have to do some homework.
I'll provide that.
Yes, isn't it? You also assist in that manner because evidence we have seen. This is the evidence. Now suppose you can connect the dots. Then this court can go ahead. But suppose there are two views.
Yes.
And the other view has to come out from, it is not something in suggestion that has been made, not that.
taken care of the family also.
The judgment has relied upon PW9. PW9, I don't think.
Yes, it is, yes, identified one of the.
No, not that part. Dealing blow.
No, even who was also clear on certificate was dealt with the flow, but he has identified it to never get the.
In cross, she said something else.
Yeah.
In cross,
I have not.
she has made a contradictory second part of the cross, I think.
That is, there was also named anyone.
She has not named anyone.
There was a one who was given worship, but he is not in the person. But worship is second which saw the Hanmani. Ananto. Ananto, yes.
She says, I did not see Nathu being assaulted at that time.
The last part I cannot say accused, so Ananta making assault. Yes.
Thereafter, she said something. I could not recognize.
Some person will say couple of blows to the boy with the yes, possibly name the person.
Some person. He does not name.
But Lokit, he has identified and also as in a part of the very specific.
I recognize accused is the unknown God. See,
Yes,
that
but
is why I'm asking for that chart. You can also, both of you can do it because that will help. You can have this matter again on Thursday. Give us the chart. In carrying those the authorities on circumstantial evidence, pick one of them. All right, then we'll continue this case on Thursday. Pardon part. It's on Thursday. Thus, you've understood what this court is asking for, no? Those. Then appears for the petitioner on call, Mr. So-and-so, your name? B. Sharma. B. Sharma, APP. It appears that the last occasion, 17/3/2015, 6/3/2025. Also, there was no representation on behalf of the petitioner. In view of no representation on behalf of the petitioner repeatedly or since 17/3/2015, matter stands dismissed for non-prosecution. You want to say something? Yes, Mr. Hajorika?
It's a main matter.
Hmm?
The number 298, payment and 323 matter.
498 and 323. Yes. Order,
Paper books, available in the report, madam. Paper books.
paper book.
Yes, madam.
What is the order that is under challenge?
Passed by the session, sessions as matter. In the
Appellate court's order is under challenge. Yes,
court said for this matter.
Huh?
Two courts said for
concurrent finding. Yes,
6 months, 10,000 rupees.
yes. What is the error in the appellate court's judgment? I shall only go to the evidences if you first show that the concurrent, the findings of the concurrent court, the two courts are perverse, no evidence, number one, or has acted against contrary to the law. Then I shall look into the evidence. First, you show it from the judgment.
Permit has expired, my lord. Yes. No, it's not there.
Huh?
No, it's not there. Given my lord, he has made some compromise,
He has what?
made some compromise, my lord, in between these matters. The statement of PW1 is, my lord.
Rajorika, I think I have made clear to you. Please show it from the judgment. First, because I'm not an appeal, I'm not exercising the powers of an appellate court now. This is a revision. Jurisdiction of a revisional court is limited.
I think it's senior mayor.
Sorry?
I think it's made it earlier.
All right. After some time.
Sure.
Sewage treatment.
Because every time this many people are not there because.
Pollution.
Last two, three
Last
occasion
time also I think he was not.
Yes.
Siddharth Mr. Borwa.
In fact, on last occasion, my lord, Lordship has also directed that his name should be reflected. That's it. His name has been shown.
Name is there.
Yes, it is there.
Mr. S. Borwa.
Otherwise, it's a covered matter of a Delhi, division bench of a Delhi High Court.
So we
Anyway,
not there.
at the
But
last,
last occasion also, if I
on
recollect,
last two occasion, he was
but then
not
later
there.
he had come.
And your lordship indicated
I
also in
think-
the order.
I
dated
think he had
13/12.
come. Thereafter, I think he had come. Anyway, because in the morning, this matter,
What we can do,
Kept
my
for
lord,
some
we
time.
intimate him.
yes,
the
you both
next
come
occasion.
together. Or otherwise, if on another date, then you let me know through your junior.
Miller.
You are appearing for pollution control board. Huh? He's on his way. You saw him. You saw him or you called him?
Then I can start.
Yes.
Lordship, to kindly come to page 23 and 24. These are the two orders which are under challenge.
23 and
24.
yes.
It is for the general information of all concerned that all ongoing, upcoming and proposed housing, commercial, office complexes, educational complexes, including IT and infrastructure and town development projects, entertainment projects, resorts, etc., having built up area of 2,000 square meters and more within the state of Assam must obtain prior control from the Pollution Control Board Assam as per Water Prevention and Control Pollution Act 1974 and Environment Protection Act along with the rules thereafter before commencement of the civil works. Henceforth violations will be dealt with in accordance with the law. This is one, my lord. And the next one is at page 24. It is for the general information of all concerned that the following all existing, ongoing, upcoming and proposed industrial unit processes established must obtain prior consent to establish and consent to operate from Pollution Control Board, Assam, in accordance with section 25 of Water Prevention and Control Pollution Act 74, section 21 of Air Prevention and Control Act 1981 and rules made hereafter. Well, the petitioners are the real estate infrastructural development association. Basically, we are onto housing complexes. We are not commercial organization. So our say is that our first challenge is, Millard, these are all executive instructions. By way of an executive instruction, you cannot, impose any further condition which is not there in the act itself.
Now, this second, page 24,
Yes.
under this, your requirement is, earlier there was a prior consent
Yes.
required if one has
Now they are insisting on both.
a consent to
Consent to
establish and
establish,
consent to operate. Both.
These are terms synonymous with industry and all. But it has got, the Delhi High Court has dealt with similar statute, similar prescription, where Delhi High Court has given the judgment which you have annexed. Now, if your lordship to
No,
kindly
but
come.
what about this proposed housing commercial?
No, we are only for the Millard housing complexes, not commercial ones. The one who constructs flat for sale to private owners.
Residential, you
Yes.
mean residential?
Yes.
And housing commercial, you mean is
Those
semi-residential?
may require minute because we are not. on
You
that.
are only residential.
Yes.
So
Now, my lord, that-
one of your argument is therefore you are not covered by the notice. That is one of your arguments.
In fact, my lord, if your lordship kindly permits me,
Yes,
I can
yes.
straightway go to the Delhi High Court judgment. If your lordship to
So,
kindly come.
is,
to
are,
page-
what is the impugned order here?
These are the two
These are the two you are challenging. This is the two. Anything, so after this, they have done anything?
No,
They have
because
not.
the stay orders are operating, they have not done it. Also. Now, if your lordship to kindly come to page number,
So why I'm asking because Mr. Chaudhary, I have forgotten the fact.
yes,
So that is why, since I have to author the judgment, so I was just trying to understand the facts also. So because these two, by these two orders, now you, unless the consent to operate is taken by or given. you-
can't even
you can-
start a project.
But then if your argument is that this is not covering you, then why are you apprehending that?
No, my lord, they're insisting,
That is why I'm asking,
huh.
by which, is there any letter?
yes, please come to page 23, my lord.
So this is a notice.
The very first word, proposed housing. So housing is a my lord residential flat.
Page 23,
Three, yes.
proposed housing,
Upcoming and proposed housing, the word, my lord.
housing, and then is there a
Slash
flat?
commercial,
Oh,
slash office complex, education, etc. We are only for housing.
this is of 3rd July. And the earlier one was 18th May.
And my lord, there is no statutory backing. Let us be very clear. It's not that any statute has prescribed it. It is a notification of the Millard Board. Now, all depends on interpretation of two provisions, section 25 of the Water Act and section 21 of the Air Act.
Yes.
Now, if your lordship could kindly come to the legal provision, my lord.
Yes.
Please come to page number 63, where in the Delhi High Court judgment, my lord, section 25 of the Water Act is incorporated, extracted rather.
Yeah.
And we see the heading itself. Restriction on new outlets and new discharges. This is under the Water Act. Subject to the provisions of this section, no person shall, without previous consent of the state board, establish or take any steps to establish any industry, operation or process, or any treatment and disposal system, or any extension or addition thereto, which is likely to discharge sewage or trade effluent in a stream or well or sewer or on land, etc., etc. So it is in this situation, my lord, a prior consent is required by the, as prescribed by the statute. That is We do not fall in either industry, nor it is operation, nor it is a process. Constructing a house to be sold to residential owner doesn't fall in either of these categories. So this is one, Milord. Then Milord will kindly come to page 66, where section 21 of the Air Act is, Milord, quoted. Subject to the provisions of this section, no person shall, without previous consent of the state board, establish or operate any industrial plant in an air pollution control area. The heading itself, my lord, is good enough. It's not an industrial plant, house building. Provided that a person operating any industrial plant in any air control area immediately before the commencement of section 9 of this so for which no consent was necessary prior to such commencement, may continue to defend a proviso takes care of a different situation. So, my lord, section 21 out of question. Now, please come to the view of the Milord Delhi High Court, whether that is a plausible thing. Now, please come to Lord paragraph 2 and 3.
Page?
Page 61.
Yes.
Writ petitions were filed challenging notices issued by Delhi Pollution Control Committee to the writ petitioner or penalties levied, which were paid under protest or bank guarantee submitted by the petitioner, which were under threat of being invoked. The petitions have succeeded not in full but in part. Directions have been issued to DPCC to take action afresh and guided by the decision of the single. The buildings with respect whereto action was proposed to be taken or was taken by DPCC are three kinds: a residential housing complex, commercial housing complex, and shopping mall. Actions were initiated or decisions were taken on the allegation that with respect to buildings constructed, writ petitioners had not obtained consent to establish as required under Water Act, after referred to as this so, and consent to operate as is required under the Air. The issues have been debated before the learned single judge and even before us with reference to sections and so and so. Thus, we begin our charter journey by noting these 8 provisions. So, my lord, this is the case. We are concerned with residential housing complex. Now, my lord, we kindly come to paragraph number 21 at page number 75.
Yes.
The error committed by the learned single judge is to mechanically note the definition of operation and process and ignore the sweep of the span of the two words. We do so. Operation is defined as an activity or an act of practical or technical nature, which emphasize on acts forming a step in a process. The word process is a going on action or a continuous series of actions directed at a particular end. Thus, an operation would be working or an activity where core of the act constituting the activity is of a practical or technical nature, especially one forming a step in a process. And since process is an ongoing on action or a continuous series of action directed at a particular end, the conjoint reading of an operation and a process, or even if the two have to be read disjunctively, would mean the expression establish or to take any steps to establish any industry operation or process, or any treatment and disposal system, or any extension or addition thereto, which is likely to discharge sewerage or trade effluent, would mean to take steps to establish an industry, establishment or undertaking where operation or process activity is of a practical or technical nature, at the core of which is ongoing act in a series directed at a particular act. Now, this is important. Thus, the act of ablution in a toilet or washing vegetables and dishes in a kitchen of a residential complex within the presence of residential flat by no stretch of imagination can be called or labeled as an operation or a process. The view taken by the learned single judge pertaining to shopping mall and commercial shopping complexes on applicability of Water Act is accordingly upheld, and view taken pertaining to applicability of Water Act to residential housing complex is incorrect. A building where shops would be made and in which some goods or services would be sold, as also shopping malls would be building where operation or process is carried on for the reason that be places where activity carried on is of a practical or technical nature, and at the core of which activity would be ongoing acts in a series directed at a particular end. If goods are purchased and sold, the sale and purchase of goods, if service is rendered, the rendition of service directed towards a particular end. If from these buildings sewage is discharged, since sewage effluent as defined in section 2A of the Water Act remains effluent from sewage system. If these buildings are intended to be established, necessary permission will be required from the board under the Water Act. So, my lord, other than residential, it is required. With respect the decision of the, as reported in so-and-so, where it has been held that constructing a building per se is not an industrial activity. The view taken by the learned single judge that constructing a building, whether to be used for residential purpose or to be used for a commercial shopping complex or for shopping mall would be an industrial activity running contrary to the aforesaid judgment is incorrect. Then the Lord will kindly come to paragraphs, my lord, 27 and 32. To summarize the position under the Water Act, the position may be summarized thus. Section 25(1) of the Water Act would apply where a building is proposed to be constructed to set up an industry or carry on an operation or a process as explained in para 21 above. And this would mean that Water Act would not apply to buildings housing residential apartment schemes. It would apply to all other buildings where effluent or trade effluent is discharged, be they where manufacturing activities carried on, sale or purchase of is carried on, or services are provided. So other than residential, it will be required. Then my lord will kindly come to para 32 and page 79 on the applicability of Water Act. Since the learned single judge has noted the unamended section 21, and since the amended section 21 requires prior consent even to establish an industrial plant in a air pollution control area, agreeing with the reasoning of the learned single judge that in view of the extended definition of the expression industrial plant, which includes a building where a trade is carried on, the inevitable conclusion has to be that prior consent under the Air Act will be needed, where building is proposed to be constructed, where from trade would be carried on, and since from a shopping mall and from a commercial shopping complex trade is carried on, we hold that prior consent under the Air Act will be required when commercial shopping complexes and shopping malls are established at the commencement of the process of establishment before building construction activity. So, my lord, be it under Air Act or under the Water Act. the
Residential
residential
complex
plant-
within Nagin.
I think it's a plausible view, my lord. This is our case rests on this.
Anything else?
That's all.
Yes, Mr. Bohra? On what basis have you issued this,
First of all, my lord, what is the statutory backing?
on what basis have you issued?
First, let me answer the first question that has been posed before me. The statutory backing is that is pollution board is a statutory authority. So we have every right to decide what is the parameter, what is the benchmark.
Correct, but provided it is in terms of the act from where you are deriving your
Yes,
power,
yes, the act.
Correct.
I'm sorry, I think I ought to have known, but I ought to have.
you have a right to reply.
I ought to have pointed out one thing. But 19, Article 19(1)(g) gives us fundamental right to do business. Now, if my
Very
understanding
restricted.
just now made a submission that Pollution Control Board is a statutory authority, therefore they have right. Now, yes, it is a statutory authority. But when we refer to statute, it means law. So, my lord, Article 19 says, when you impose reasonable restriction, it has to be by law. Law means statute, not my lord, executive
Yes.
resolution of the board.
That's why, Mr. Chaudhary, my immediate question to Mr. Borua was under the law. So, yes,
So also the petitioner's case is based on the strength that the Delhi High Court has decided upon a matter whereby they have said that residential complex doesn't come under the ambit of going for a sewer. So this entire thing is based on that. Already Lordship has gone through the relevant paragraphs of the Delhi High Court judgment. Now, my point of argument is that since in Delhi, that is the Union Territory of Delhi, they have already a fully functional sewerage system in force since years.
wait, before we go to
So
that
that is-
part, Mr. Borua, before we go there, see why I'm interacting with you is to give you an idea as what is going on in the mind of the court after hearing the
Yes,
petitioner's side.
definitely.
Because you have to reply accordingly, correct? Now, what is under challenge before this court is the document on page 23, correct? Now, please read that document one. Just read it.
Yes, and paragraph 23.
Yes,
It is for the general information of all concerned that all ongoing, upcoming, and proposed housing public, commercial, official complexes, educational complexes, including IT and infrastructure.
that we are not concerned. Having built up area
Of
3,000
Okay.
square meters must obtain prior consent,
by
correct?
consent from Pollution Control Board Assam as per water.
So and so.
Regulation
Now,
and
as per so and so, right? Along with rules made thereunder before so and so. So it seems that as per the provisions of the Water Control Act, you are putting these
Yes,
restrictions,
yes,
right?
yes.
Now show me from the act, which gives you the power of of seeking for a prior consent to operate
Yes, for that matter.
for housing complex.
For that
So
matter.
you have to first
me-
show me from
let
the
me-
act.
Let me also.
Please understand
clarify.
from the act,
Yes,
because you see, you admit that you derive your power from the act.
that's what I'm coming.
Huh.
So for that matter, already that the provision has been read before your lordship, but still I want to
Yes, yes,
continue
please,
with it.
please.
Yes, the water prevention has the provision, section.
20, 25?
Yes, 25.
Yes, please.
Yes.
Yes,
25. 1A. So subject to the provisions of this section, as your lordship.
yes,
And no person shall, without the previous consent of the state board, establish or take any step to establish any industry, operation, or process, or any treatment and disposal system, or any extension or addition thereto, which is likely to discharge sewage or tread effluent into a stream or well or sewer or on land. Such discharge being hereinafter in this section referred to as discharge of sewer. So here, the very discharge of sewer from a residential complex comes under the parameters of the definition, which encompasses commercial, non-commercial, residential, doesn't matter, but it has to have a discharging process. Now, parallelly, if I take your lordship to section 17, function of the board. Section 17.
yes,
Subject to the provision of this act, the function of a state board shall be to plan a comprehensive program for the prevention, control, and abatement of pollution of streams and wells in the state, and to secure the execution thereof. So these are the basic functions and parameters under which we have to abide by, because we are
apart from anything else, our basic parameter in our purpose is to prevent and conserve the nature. So whether the set norms has been set, and because the environment EI notification, as the petitioner was referring to, it sets a norm of 20,000 square meters. So that has been set with regard to Ministry of Environment and Forest. So as regard the projects which are lesser than that quantified amount, so does it mean that they don't do any pollution, they don't damage the land and the rivers and the other water bodies? So for that matter, these matters has been entrusted upon the pollution control board. So we have set a norm whereby 3,000 has been set, lesser or equal to that square meter. Because ultimately the sewer that will be, because in Guwahati, we don't have a common sewer disposal system. This is already there in existence in Delhi. While discussing and debating upon that judgment of the Delhi High Court, they, even though knowing very well that Delhi has a disposal mechanism in for years together, but they were referring to ablution. Now ablution.
All that part is reflected in
That's
the
what-
judgment
And yes,
about the system which is prevailing.
that is a known fact.
No, but I'm asking, is it there in the judgment?
Because ultimately the process, the operational process has been defined there. So what is this operational process? If we go by the definition of this.
If I am understanding both the arguments from
Second
both sides, perhaps the issue which falls for this court to determine in this petition is as regards whether housing
Housing complex.
is included in 25 or not.
Yes,
If it concerns with sewage disposal,
yes.
right?
And
That is the issue.
yeah, that is the
That
issue.
is
And-
the issue.
And the
Now,
plain reading of the
according
Delhi
to-
High Court judgment
acco-
says that.
That,
residential-
you see, Mr.
Yes.
Borwa, that's what I'm saying, we'll go to that later.
Yes.
Because, this court is not bound by the decision of the
Yes,
Delhi High
definitely.
Court, right?
Because we
So
have to
first,
think in
therefore, first let us see, what is your take? We'll go there. Since it is obviously, persuasive. So it is definitely has to, this court will look into it, but first, you show me from 20, because what you are trying to say is that because of the, fact that under 17 also you have a
We have-
obligation to
preserve and conserve.
make a plan for a comprehensive plan.
prevent-
Now, whether that and 25 is connected,
Yes.
not connected, you have to show all that also, because 25 is restrictions. When it talks about restrictions, you are restricting something, you see, because that has a effect in the right of business, livelihood, everything. The fundamental right also gets affected, correct? Now, therefore, I'm asking repeatedly there, how only, now, when you see A, subsection 1A of 25, first it talks about to take any steps to number one, establish any
Establish any
industry, operation or process or any treatment and disposal system or any extension or addition there. Correct? Which is likely.
Yes.
So
This is not.
these are the first. Now, housing is not part of the first part. The first part talks about industry. The preceding words, operation, process, or any treatment and disposal system, or any extension or addition thereto, seems to be in relation to some industrial activity. I am only giving you I am just showing my perception, this court, what is perceiving in the mind of the court. Because we'll have to interpret.
That was, we are trying to
Correct.
interpret and
We
bring
have
the
to
fact.
add the word housing in subsection A of 1. Isn't it?
Yes.
I think, Mr. Chaudhary, that is the, whether we can do it or not, then the interpretation, everything is.
generis.
Correct. So this is one perception that is coming. You see, don't get anxious because you are replying. So that is why I'm only expressing the mind. You see, because once we hold that housing included, not included, then everything will fall in its own place. But first and foremost, this is the hurdle that you need to cross. Now, showing 17 will not take you anywhere. 17 is about a comprehensive plan.
That is.
Correct.
Yes.
17 is only talking about a comprehensive. You
primary
definitely have an obligation.
That is the primary obligation.
Correct.
Yes.
But
But
from
as regard
25,
25, we go on interpreting on that context because ultimately, when this statute was it is for 72, then it got amended year after year. So that point of time, that no one was wondering or imagining of building complex with
But
3,000
these
or
things have to come out from
subsequent-
somewhere.
yes, but
Your
yes,
decision-making
that matter,
process.
for that matter, MOEF issues circulars and directives to the state pollution board from time to time. It is not that 2006 is the only circular that has been issued by the MOEF, whereby the set norms for with regard to construction activities of 20,000 and all have been set there. That apart, we keep on receiving circulars every other day. So these circulars, ultimately the authority has been entrusted upon the board to do and decide as regards the prevention and control of pollution in the state. So accordingly, we have done our best part, and that we intend on with all the other stakeholders. And stakeholders, basic purpose of GMC, GMPA, or whatever the or any town planner is to save and conserve the water, and also from having it not being discharged into a river or any such water body. As we can see very well, what is the condition and what is the state
That
of-
is okay,
So,
but
for that matter,
you
we have
see,
said
now, suppose you are also in a way admitting to the fact that at the time when this act was enacted in
time to
74,
time it gets amended.
because there was no housing complexes, it was not part of section 25A. Then how can you make this restriction without the backing of a statute then? Because at the end of the day, now fundamental
Now-
rights are getting
now
affected.
if I go,
If you see, Mr. Borua, for that, you could have amend the act, amend the provisions. I'm only giving you
no, that,
another. Now, where is your stand in the affidavit? Let us see your stand in the affidavit. How have you explained this?
now the relevant maybe that just circular B of three. I was,
Yes,
here I was trying to bring home the fact that,
he is again Delhi High Court. Delhi High Court later.
so let us
But
see.
you have to
So while-
show what were the reasons, where is your decision-making process?
Yes.
All that you have submitted before this court, whether these are mentioned in the affidavit or not.
the D. The impugn notices dated so and so respectively annexes to and three of the resolution are interrelated and has been issued not only under the provision of the Aquatic Water Act and Air Act, but also under the provision of the State Environment Protection Act of 1986. The rule and the rules made thereunder. Further, in pursuance to the said two notices, only NOC has been issued from the board regarding housing complexes, etc., having built up area of 3,000 square meters. That is habitation of around 32 families within the state of Assam, and on the other hand, consent to establish and operate in accordance with Section 25 of the Water Act as well as the Section 21 of the Air Act, as we have already discussed earlier. Has been sought only for the sewage treatment plant, restaurant, dhabas, businesses, and not for any residential complex person. Now we go on to that EI notification.
What are those?
EI notification of 2006, whereby it sets the parameter, what all are categorized in red, orange, and green.
Okay, that I remember on last occasion, I think my attention was taken to those two notifications. You let us, anyway, we'll have a look at that, but carry on reading E.
The EI notification deals with the prior environment clearance, EC, and the central government or the state level environment impact assessment authority. And the state environment clearance cannot be equated with NOC, oblique consent of a state board under the Associate Fee Act. So that EI notification, parallelly, if I just take your lordship to page 31 and excerpt 2 of my affidavit.
So it seems your only explanation is that you have done it as per 21, right? Water?
25.
No, water. 21 of the water?
21 of the Air Act.
Sorry, 21 of the Air Act and 25 of the Water Act. This is your explanation.
That is a. And for
But,
that matter, I have been supported-
but what you tried to improve that is not part of your affidavit.
And for that matter, I have to also take the support of my complaint. So the thing is very simple. As regard that parameters that have been set as 3,000. So when I go into the reply section of the petitioner in their counter, so they haven't disputed that 3,000. They only talking about the economic viabilities of setting up a
So all
project.
that
So that,
all that this court is not concerned right now.
so
The
their
first
conclusion is that
issue,
it is economic.
first
not
issue
fine.
that this court has to decide is whether housing is included in subsection A1
And
of 25.
and we all.
Right.
all we have
Now
to make
that on a plain reading doesn't appear
residential complex.
residential housing,
And
housing
whether-
or residential,
whether-
that is not there.
Whether ablution and discharge of kitchen and other ways,
Whether it can be
needs to be-
connected to for the residential also, because
we
it,
understand the same as sewer,
Alright.
as defined in
no,
the.
because it has to be understood in context of, it appears that that is in context of industry. Industry,
That's what,
right?
the definition of sewer is.
And you admitted in your argument that it's in the year 74 was not there.
That point of time, for anything that industrial activity hasn't been defined here, what needs to
Correct.
be defined as.
So if there is some lacuna in the statute, one can fill it up. But if there is a process of doing it, right?
Exercise has been
Now-
done. or
Now,
not
now
with
it
regard to-
appears there is no statutory anything which includes the word housing or residential in 25.
No,
That
never,
has not been done.
never, no
And
commercial.
your reply in paragraph D simply says that this is done under the provisions of 25 and 21.
One, but that apart, we also have the Master Act, that is the Environment Protection Act of 1986. So it is not that we are only concentrating and limited only to.
Any other paragraph from this affidavit that you want to
Those are
rely?
enabling provisions, and it has a much wider amplitude as regard the protection of environment.
Any other paragraph you want to rely from this affidavit?
Yes, my affidavit, if you're not, I have just, related some of the paragraphs. And if you
Yes.
see while studying the matter, and definitely go into the. So there potentially is as regard the exorbitant fees and as regard the qualified area. So here, Lordship would refer to that government of Assam notification, amended notification. This is annex as annex 3 to my affidavit.
Page?
Page 30. So these has been done in.
Page 33. 33 of what?
My affidavit. Somewhere. Your affidavit in opposition file, by the.
Okay. This is 118 continuing. Yes.
So the fees have been decided based on this,
What has been decided?
the fees
Fees.
that is to be paid, because ultimately they are challenging that also in one.
These are consequential.
Yes. That apart, also may also refer to paragraph 5 of my affidavit. Paragraph 5 of my affidavit.
Yes.
I cited the reason of wastage.
Yes.
Yes. Nothing much there, because ultimately our basic target is only to preserve. That is all. And that we have done. with the-
Okay. Definitely, this code, there is no quarrel to that obligation of you. You definitely,
not that
it
we
is
are-
imperative for the
we are-
pollution control board to preserve and maintain,
We are
but you
not
have to do
bound.
it in accordance with law.
With law,
Here is the law supporting 25.
that those decisions are taken by the board in their own capacity. The board sees over the matter, they decide. It's not a one man.
But where are those? In the affidavit, you don't talk anything about that.
Affidavit, I'm not.
Correct. Then if you have not said all this, then how
I
can
am
this court go into that?
I'm arguing based
What is
on the
challenged, you
purpose-
see, Mr. Borwa, what is challenged before this court is the validity of those two notifications, which you say it is issued under 25 and 21. Then in their reply, they have said, no, it cannot be done under this. No, but you have not brought out the records, neither you have supplemented in your affidavit the reasons. You are simply saying under 25.
Then let me produce the record. Also,
Too late now. Yes, Mr. Chaudhary,
Milord, on by way of reply, Milord, I'll only say, can we have Article 19(2)
can we have it at 2?
Article
Can we continue at 2? But it's coming. Where has Mr. Borwa gone? Mr. Borwa, as regards the Delhi High Court judgment,
yes, that's what I was just thinking.
Yes,
was
yes.
just now.
because I think you didn't get an opportunity to
No, no.
distinguish it. Yes.
Like, after last occasion, when Lordship was dealing with this matter, so also wanted to know, and we had not a counsel for the GST was referring to a Supreme Court judgment whereby all the commercial establishments, including hotels and other establishments, are required to set up a effluent treatment plant. So, if at all industries which require consent to operate from the board, if at all they don't establish it within 3 months from the date, then the position board has been directed to take action against those earning industries. So in this respect, I've got the judgment. In fact, since small establishments are required, including the small garage.
That is the, you see,
Small
those,
garage.
that is a different aspect. Right now, what is challenged before this court is those two notifications, right? Whereby you have made it uh, mandatory for for anybody who is building a housing residential complex as well to take prior consent to operate and consent to establish.
Yes.
Now, your stand in your affidavit is that you have done it as per section 25 and 21. This is your stand in the FIR, nothing much more than that. That is one aspect.
Yes.
Now, the second thing is that how do you, what is your argument
Now,
as regards Delhi High Court judgment? Your stand is there at page 88, paragraph B. Please read that.
of the Delhi High Court.
No, of your affidavit. Mr. Chaudhary, I'll come
Yes.
back to you.
Paragraph.
B.
The revision bench of Delhi High Court in judgment dated 24 connected letter is explaining section 25(1)(a) of the Water Act, while inter alia stating the act of ablution in the toilet or washing vegetables and dishes of a residential complex within the precincts of residential flats. By no stretch of imagination can be called or labeled as an operation of process. Also clearly states that the operation of process, that is activity of a practical or technical nature, at the core of which are ongoing acts in a series directed at a particular end. Since the meaning of the word sewage and ablution, public washing, are vastly different in the present context with the municipal sewage system in existence, the Honorable Division Bench of the Delhi High Court has specifically mentioned the word ablution of the washing instead of sewage in the aforementioned judgment, so that the act of ablution in the toilet or washing vegetables and dishes in the kitchen of a residential complex does not come into the purview of an operational process. So those are
All right.
has been put in inverted commas.
Now, I think that's all because you've already completed your argument
I
because
have
of like,
completed, but Lordship wanted to have a difference between the commercial activities as defined in section 25 and also the residential discharge. So
Residential
since
discharge?
production and process has been mentioned in regard to section 25, establishment or take any step to establish any industry, operation or process, or any treatment and disposal system, or any extension or addition thereof, which is likely to discharge sewage or trade effluent. So the trade effluent cannot be discharged by a residential complex. So that makes a quite striking difference between what is trade effluent industrial waste and what can be the discharge from a residential flat or an apartment or a society. Now, if we just turn.
no, but discharge sewage can be also from a commercial,
Definitely.
correct?
The trade effluent,
Huh.
that is a terminology, trade effluent.
Trade,
Now,
that is
we have
industry.
to take the assistance of the definition that has been given in the column of definition. For that matter, if you're also putting the
Yes.
water right. May I take your look to definition 2G?
Yes.
So sewage effluent means effluent from any sewage system or sewage disposal works and includes sludge from open drains.
Basically, sewage is a sewage effluent is a general word. It's a general word. But the only specific word used in 25 is industry.
Because ultimately 25 just slashes between what is sewage and what is trade effluent. So that makes us quite
What is
trade effluent. Trade effluent.
trade effluent?
The trade effluent,
That could be because
The
trade
industrial waste.
effluent is only industry,
industry,
whereas there can be commercial complexes,
commercial.
shopping malls, restaurants. That is why sewage.
That's why Delhi High Court has just narrowed down its discussion on only to those matters.
See, I'm not on that right now much because now just because in Delhi something is there
Yeah.
doesn't mean the section 25 will be interpreted in that context. Section 25 is not is a central act, correct? It's
Yeah.
a part of a central act.
Yeah.
So it cannot be interpreted in context of Delhi something else. It can be interpreted in case of Guwahati something else. That cannot be. That is a different. By the by, they may have observed that. Anyway, I am not on that. I am on a very specific point here because the word industry
Just get-
is a specific term. And the words of preceding industry used in section 25 is operation or process or any treatment and disposal system or any extension or addition thereto. These are all generic words,
Yes.
right? Which thereto, which is likely to discharge sewage
Mhm.
or trade effluent into a stream or well.
Yes.
Correct. Now whether the word operation, process, treatment, disposal system, extension would also, if it's there on a particular residential complex or a housing complex, can be set to covered under subsection A1 of 25.
That's what I'm trying to.
And for that, the well-known principles of interpretation also cannot be forgotten because these are generic words. Now,
These are
when they are
generic words.
generic words used along with a specific word, one has to understand in that manner. Now, you see,
Why-
trade effluent you have
Yes, trade effluent is
is
also
K.
defined.
Define K.
K.
Includes any
Includes
liquid,
any
gaseous.
gaseous or.
That is because that is part of an industry. That is
part
purely
of industry.
industrial activity.
Yes.
But what about commercial residential complexes? There are complexes which have commercial activities going on.
No, that's why the board has decided that it's not that only industry discharges sewage and trade effluent. It is the residential complex of use size with 3,000 square meters or above.
Where are
Because-
those in your affidavit?
No. Ministry of Environment and Forest has set a norms as regard 20,000. If at all 20,000 square meters of building can discharge.
Where is that?
effluent,
Where is that?
That is very much clear here.
Where?
Yes, I have also mentioned in my affidavit also.
The 20,000 is where?
20,000 as said in the EIA notification.
Where is that?
Yeah.
You see, because the principle of ecosystem generation is well known. Suppose you show me a contrary
mentioned it
intention
there.
from the statute, then that cannot be restricted. That
No.
meaning cannot be given that. Correct, but you have to show
That's
something.
what I have debated and discussed in paragraph 6 of my affidavit.
Paragraph,
6. I'm so sorry, I couldn't provide with the running pages.
so that's all right. Paragraph 6.
Yeah.
Yes, read.
And that with respect to the content of the paragraph number 4 of the incident writ petition, this deponent humbly states that as by EI notification SO 1533 dated 14/9/2006, the building and construction project, irrespective of its category, requires environment clearance for a built-up area of 20,000. So, built-up area of 20,000 square meters and lesser than 1,00,000
3,000.
Square meters, which indicates clearly that building and construction process, irrespective of this category, has impact on environment. Further, it would be relevant to state that in Justice R.S. Verma versus State of Rajasthan AI 2004, the Honorable Rajasthan Court sitting in the division bench while holding that concrete jungle are swallowing green area, that trends to need be halted to protect and preserve ecology. Also quoted from a Supreme Court judgment elaborated in Article 21 of the Constitution that enjoyment of life and its attainment, including the life to life with human dignity, encompasses within its ambit the protection and preservation of environment, ecology, ecological balance, free from pollution of air, water, sanitation, without which life cannot be enjoyed. Again, White Circular number of 21st November 2006. It has been classified by the Ministry of Environment and Forest Government of India that consent to establish NOC and prior environment clearance are separate legal requirements.
These notifications are not on the challenge, right? Now,
They're not on
where,
the challenge.
where is 14/9/2006?
Because ultimate
Where do I find 14/9/2006 notification?
49, I think it's part of the.
Page 41. Building and construction project. Township. $20,000.
Yes.
But these construction are whether residential or commercial, how do we know?
Anything, any construction.
Anything. It could be either residential or commercial.
It doesn't make a difference.
But this is issued by Government of India and is under what? Yes. This is under the environment.
Yes.
Isn't it?
Yes.
Rule 5 of the Environment Protection Rules 1986. How is this applicable to 25 under the water? Because this is the environment under the Environment Act.
No, this is issued by the Central Pollution Control Board. Again, apart from that, in
Page
2006.
41.
Yes,
Let's see page 41. Where is a draft notification? Isn't it? Now, therefore, in exercise of the powers conferred subsection 1 and 4, 5 of so and so 3, read with so and so environmental protection rules, and so except so and so. You hereby direct that on and from new projects or so and so listed in the schedule to this notification entailing capacity addition with change in process and so and so shall be undertaken only after the prior environmental clearance. You build it up, you are bringing, you have to develop your argument. You are trying to say this visualizes residential and housing, correct?
Yes.
And you want to rely on this.
No, I'm not relying. I'm saying that in parallel count, when the Central Pollution Control Board can decide on what area of land encompassing a building can have a
That is
serious
under
constraint.
different act.
This is under the Central Pollution Control Board. This is under the Environment Protection Act.
Correct.
Environment Protection.
14 September is under the environmental protection.
And we also said it under the environment. The board is considered.
But you have taken action under the Water Act.
No. Water Act is another sub-act.
Correct.
The parent act is the Environment Act. Under which we
Specifically, you have
Air
done
Act
it
and
under
we have
that.
all other acts. So now
So
the
what is
action,
your argument?
my
I
argument
understand
is
your
that the entire action has been taken based on the said benchmark which we have developed on us, based on the thing that we need to preserve and conserve the environmental degradation of the land, the soil, and also the water bodies, because this discharge at a higher amount will definitely pollute it in every coming day. So we have done it with that motive, and for that matter, we are being supported by other stakeholders, including the GMC and GMC.
At the cost of repetition, Mr. Bora, I'm again asking you, where have you said this in your affidavit?
What?
What you have just.
We have stated that we have to
In
work
your
in tandem
affidavit.
as regard all the
In your
stakeholders.
affidavit.
I have stated.
No, not only, okay, let's see that
I have
paragraph. How you have seen.
Yes. I have stated your logic with paragraph 7 of my affidavit. With respect. Yes, of the incident restriction, your deponent humbly states that the GMDA, GMC, or other municipal authorities permit the haphazard construction activities without taking into consideration the vitally important aspect of environment and sustainable development, which may impact on the environment very badly, disturbing the ecological balance. Till now, in most of the cities and towns of Assam, construction and development work are carried out without being careful enough for protection and preservation of environment. The environment friendly practice, that is optimum use of natural resources like water and judicious use of electricity along with proper environment friendly design of all development work, are some of the focal points which are to be incorporated in all our development and construction work, etc., for a better future ahead. The scenario is possible when all the stakeholders, like various government agencies, development organization, including builders, etc., show up some respect to the environment protection and improvement aspect, and there is proactive cooperation among all concerned for greater interest of the environment. However, regarding consideration of GMB and GMC for obtaining the consent of the board as per prerequisite for grant of building permission is obviously for the interest of prevention and control of pollution. So GMB and GMC have written to us that prior to getting the consent from them, the authorization from them, they need to have an authorization from us as regard construction and as regard sewerage treatment plant. This is set the target of benchmark of 2030. That is a principal objective.
Where is this orange category and all that? At list. So give me the page.
Page 20, 22.
Look.
Yes, 22.
The para 10 is more specific in your estimate.
Para.
10. From the above notification, it is clear that all building projects irrespective of categories may be considered for taking with the ambit of consent administration. Accordingly, under the existing laws, particularly under so and so, the board identified the building construction project with a built-up area of 3,000 square meters per unit. It has subsequently come in. Yes.
There 22. Red category.
Anything else?
No.
Yes, Mr. Chaudhary.
Yes. Lord, my first submission was
Before people have commented.
these two notifications which have been included in this proceeding. They do not have any statutory value. Because why we are saying that under Article 19(1)(c), a person who deals in business of real estate, he has every right to do that business. In the exercise of that right, a reasonable restrictions can be laid down under Article 19. But that restriction has to be in the form of a law. This executive instruction is not law. First point. That's why I'm drawing your also kind attention to Article 19(2). This instruction has to be in the form of a law. If it is not law, it's not. Article 19(2). Sub-article 2 of Article 19. Article 19(1)(a) speaks of the different fundamental rights. Nothing in subclause A of clause 1 shall effect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restriction on exercise of right conferred by said subclause in the interest of so and so, security of the state, friendly relation, foreign countries, public order, decency, morality, or in relation to contempt of court information or incitement of the contempt. So that restriction, that reasonable restriction has to be in the form of a law. So therefore, my first submission is the two impugn notifications at page 23 and 24. Or means they insist on a requirement of consent to operate and consent to establish is without any authority of law. Now, my second submission is, my lord, as far as section 21 of the Air Act is concerned, it is outrightly not applicable. Now, there is a scope of interpretation insofar as section 25 of the Water Act is concerned. Now, it says it gives three expressions. Kindly come to page that section 25 without. Subject to the provisions of this section, no person shall, without previous consent of the state board, establish or take any steps to establish any industry out of question, operation or process, or any treatment and disposal of system or
Disposal
any
system,
extension or addition thereto.
disposal system, no?
Yes. Thereto, which is likely to discharge sewage or trade effluent into the stream or well or sewer on the land, etc. etc. Now, my lord, if we go by the subtle principles of interpretation of statute, industry is the genus. This expression, operation, process, these are all basic. So therefore, it has to follow the genus. That is where we will have to apply that principle of interpretation of or principle of
Subject
just
to, of course, that nothing contrary is
Yes.
coming out from the steps.
Now, my lord, another important aspect. Now, we are relying on that notification. I'm sorry, my lord, I should have pointed out that at page 41, that notification issued by the,
I have 41 open.
yes, page 41.
I have it open.
14th of September 26, this is issued by the Government of India, Ministry of Environment and Forest. But this is a subject not under forest, but it is an subject falling under environment. But environment, pollution, these two expressions are not defined in either list 1, 2, or 3. So therefore, it is under NP 97 of list 1. A subject or an issue not elsewhere specified in list 1 or list. Then it is the power of the parliament. That is how, my lord, the Water Act, the Air Act, the Environment Protection Act, these are all legislations under NP 97 of list 1, residuary. Now, my learned friend has advanced an argument. If the central can come up with 20,000 square meter, why state cannot 3,000? That is very clear. Once the field is covered by union, the state cannot touch it.
That, of course, I'm not on
So
that.
therefore, my lord, central government in its wisdom has taken a call. They say, please come to page 45. Or my lord will kindly come to page 44. List of projects or activities requiring prior environmental clearance. Please come to the next page, 8A. Building and construction projects. Now please come to column 4. 20,000 square meter and above. If central government in exercise of power, the NP 97 of this one has come to the conclusion that only projects exceeding 20,000 square meter requires, environmental clearance. How come state government can say if they can insist on 30, why can't they insist on 3,000? It's neither here nor there. End of the day, they lack the statutory sanction to come up with these two numbers. Because prima facie reading of section 25 of the Water Act and section 21 of the Air Act clearly reveal that the exercise of the power is without limit.
The word operation, process, treatment, disposal system are
Yes.
they defined?
Yes, Mr. These are all defined expressions.
Just see that one.
Yes. My lord, in the Water Act, this operation and all are not defined. But my lord, trade effluent is defined, sewer is defined, sewage effluent is defined, pollution is defined, outlet is defined. Now, my lord, when the parent act, that is Water Act and Air Act, has not included housing complex or residential devices from operation of the act, how can state board, my lord, that to exercise of what authority we don't know, my lord?
I am trying to appreciate both sides of the argument here. Because that is the issue,
Huh.
which I see. Who is only whether housing can be said to be included in 25 or not.
Yes.
If included, the notifications can be
Because
said
if
to be
we
valid.
Go by the environment protection assessments notification, there it says it is huge project, yes.
So I am not on that environment protection.
But prima facie, Water Act and Air Act, my lord,
So
do not
because-
envisage a
because,
housing project.
See, there is a, I don't know, I mean, just coming in my mind. It says any industry, and it says operation or process, or any treatment and disposal system.
Hmm.
Now, what is this disposal system
My lord, disposal
or
system
any?
arising out of that industrial operation and process. The discharge. Discharge. So there will be an industry,
If suppose there is a discharge of sewage.
sewage. Yes,
Now, suppose this is not. See, first thing is that whether we can say that industry is the genus, and all these words are has to be understood, cannot be read in isolation.
yes.
It has to be read with industry. Then, of course, that is different. But then the entire provision has to be read,
Read.
isn't it?
Yes,
Nothing
in that
contrary.
case,
nothing
in that
contrary
case,
should
you know, the
also-
expression
because-
sewage,
because Mr.
Sewage
Chaudhary,
cannot
what is
be-
bothering
yes,
this
that-
court is the object of this act.
Correct.
At the end of the day, it is the protection and preservation of environment.
Correct.
Isn't it?
Correct.
That is the object.
that's why Parliament or the Indian government is the competent authority was of the opinion. It is in only in case of big projects where environment clearance should be required. Not in case of projects below 25. So that is the wisdom of the Parliament, my lord. That is the wisdom of the central government. Nobody is questioning that. And they are bound by that.
They have made it
Their
3,000.
their logic is
They have narrowed it down to 3,000.
my lord, sewerage, as we understand in ordinary parlance, differs in the human existence without. It was never considered to be polluted. It is only industrial waste.
Yes, but ultimately, when the apartment
My lord, in the town, in the
comes
cities,
up,
in the cities, those are being treated. Those are being treated. They do not find entry into the Milot drains. It has been treated within the premises itself. So an aspect which is not there in the act can the state board, my lord, in the name of protection of environment and prima facie, and there I am relying upon division bench judgments of the High Court, where division bench of the Delhi High Court was, yes, in case of commercial use, if it is a shopping mall, if it is a restaurant, big hotel, then yes. But if it is a residential premises, then. Therefore, my humble submission is regard. And we need not travel to those. First of all, let them show the authority under which they have come up with this to know. Which section?
That they have said in their affidavit.
25. No, 25 does not.
That is what
Yes, does
I
not.
have initially,
Yes, yes,
that explanation
yes.
that it is under 25 will hold only, they show from 25 that housing is included.
But 25 of the Water Act basically deals with industry,
That
industry operation and process. So it is something to do with an industrial activity. End uses that,
now, if I have to interpret
because why?
A
Because
to
in an
say that
industry
it does
also
not
there will be
include,
sewage. In an industry also there will be sewage. If there's a big industry, then that industry there will be, sewage. Naturally there will be sewage.
then there will be trade effluent
Hmm.
because trade effluent is defined. Which
That is
appears,
defined.
which appears to be only in relation
Kindly
to
see the
industry.
definition of sewage is also defined below.
Yes, means effluent from any sewage system.
Now
or
sewage
sewage.
is also defined.
Yes, yes,
Yes,
G.
yes.
Read.
Sewage effluent means effluent from any sewage system or sewage disposal work and includes solids and open drains.
From open bay.
From open drains. Now
And
the question
K.
is, my lord,
then K, read K, trade effluent.
came with the trade effluent. And a trade effluent is a gas and all, my lord.
Just
doesn't
read,
have-
read.
Yes. Includes any liquid, gaseous and solid substance which is discharged from any premises used for carrying out any, kindly here also, my lord, industry operation process
See,
or
that is-
treatment
that
and
is
disposal
where a
system
little doubt-
other than domestic sewage.
that
That's
is-
the, I'm
that-
sorry,
that
my
is for the trade effluent.
lord. No, my lord, other than domestic sewage.
Correct.
So this is already out.
Only for the definition of trade effluent.
Exactly.
Because trade effluent
Ah.
is restricted only to industry.
Then my lord, then they
That
were
is why you
between-
see, likely to discharge sewage or trade effluent.
You know, that
There-
is
there is a
the intention of the
distinction.
legislature to bring domestic sewage within the ambit of section 25. Section, then domestic sewage would have been defined and it would have been included. My lord, what I can foresee.
See, why this doubt is coming in my mind is because suppose it's a commercial project,
Then it is. Then
maybe
it
less
is.
than 20,000.
If it is a commercial
But
project,
you see,
then
that doesn't come under industry.
yes. Yes,
Commercial residential
not residential.
complexes are not industry. Then how can we restrict the words operation, process, treatment, disposal system only to industry?
yes.
That
So-
means the subsection A, the word industry is not the genus. Because to interpret it in that manner, it will do violation to the main object and plus 25, because something contrary is being suggested. This is a view, Mr. Chaudhary, the entire purpose of discussing is to clear all my doubts,
Absolutely, absolutely.
because nothing contrary has to appear.
Hmm.
Only then I can apply the principle, correct?
Hmm.
That is this, I don't think there is any dispute to that.
Absolutely,
proposition.
my lord. No, no, yes. Now, my lord, section 25, if your lordship kindly comes to 25(1)(a), establish or take any steps to establish any industry, operation or process,
Comma, operation.
or any treatment and disposal system, or any extension or addition thereto, which is likely to discharge sewage or trade effluent into a stream or well. Now, we can visualize the situation below, even in an industrial plant. There could be bathrooms for use of the industrial workers. But it will also will not emanate or result in sewage effluent.
But your
So that
Delhi-
is in
your Delhi High
connection
Court
with industry.
judgment, you see, your Delhi High Court judgment has included commercial
Commercial,
projects.
commercial, but not residential.
Correct, but that commercial project cannot be industry.
my lord.
Commercial project is not industry.
No, but Delhi High Court has said that commercial concerns will be included within the definition. Matlab, we are neither here nor there, we are not
That is
concerned.
the problem.
But we are concerned with Delhi High Court judgment only to that extent when it excludes residential.
Correct, but that is one part of the judgment is supporting you and
Yes.
you want that
No,
in your
Delhi
favor
High Court was
because
concerned with three different aspects.
I think somewhere in the Delhi High Court they have mentioned that it will
Yes.
include commercial. I believe
I'll
it
place
is there.
that.
Let us be clear.
Now, please come to page 79.
Yeah.
This is in the context of course, Air Act. Or before that, we can come to that Water Act part.
Yes, yes. Yes, you see 27. 27.
Now, please come to my lord, page 76,
76.
Hmm.
All right.
para 24.
Yes.
With respect to the decision reported in so and so, where it had been held that constructing a building per se is not an industrial activity. The Supreme Court, this is a my lord Delhi High Court judgment.
Ansel housing.
It held that construction is not the view taken by single judge that constructing a building, whether to be used for residential or to be used for commercial shopping complex or shopping mall, would be an industrial activity running contrary to the aforesaid judgment is incorrect. So,
Come to 27.
yes, para 27. To summarize the position under the Water Act, the position may be summarized thus. Section 25 of the Water Act would apply where a building is proposed to be constructed to set up an industry or carry on an operation or process as explained in para 21 above. And this would mean that Water Act would not apply to buildings housing residential apartments unit. It would apply to all other buildings where effluent or trade effluent is discharged, but be they where manufacturing activities carried on, sale or purchase of goods is carried on, or services are provided. So as long as it is residential premises, then it will not be, section 25 will not be applied. Similarly, para 32 at page 79 regarding CARE Act. Since the learned single judge has noted the unamended section 21, and since the amended section 21 requires prior consent even to establish an industrial plan in a air pollution control area, agreeing with the reasoning of the learned single judge that in view of the extended definition of the expression industrial plan, which includes the building where trade is carried out, the inevitable conclusion has to be that prior consent under the AR Act should be needed, where a building is proposed to be constructed, where from trade would be carried on, and since from the shopping mall and from a commercial shopping complex, trade is carried on, we hold that prior consent under the AR Act should be required. When commercial shopping complexes and shopping malls are established, that is at the commencement of the process of establishment. That is before building construction. So, my lord, my humble submission, my lord, the view of the Delhi High Court seems to be a plausible view. More particularly, my lord, that is an aspect which was not gone into by the Delhi High Court. When we try to give meaning to the expression industry, operation, and process, I think that principle of wisdom generis will come in. And secondly, my lord, that word sewage, which appears in section 25(1)(a), we cannot give a literal meaning as we understand. But that use of the word sewage in 25(1)(a) has to be understood in the context. It was used in the context of an industry. So, effluent emanating from industry, not an effluent emanating from a residential premises. Or had it been the intention to include, my lord, then the word industrial would not have been there. Any construction activity would have been there. So therefore, my lord, Delhi High Court view that section 25 and 21 cannot be applied to residential complexes is not without reason. And moreover, why Milord Assembly government came up with that notification in 2006 that environment clearance will be required for project
20,000.
exceeding 20,000? Because it is an enormous scale. So that being the position,
What is-
Milord,
Sorry.
the impute notifications are without any authority, Milord, and these are liable to be accepted.
Mr. Bora, 3,000, from where did you fix it at 3,000?
For that matter, I have left to refer to the reply that the board has given as regard to application. whereby-
3,000, just to draw
So
it out.
that-
Show me that. Because everything else, otherwise you have said it.
Because that makes
2000
very clear
Where,
why
which page?
consensus this decision has been taken by the board, how we have arrived at.
Just indicate the paragraph.
So indicating, I would just like your lordship to just,
You don't have a right to reply. You are the respondent. There is a,
yes.
I am only, you
Indication,
just show me,
so in that case,
you could have, yes,
straight away go to page 30, last part,
page
the- page 30,
1330.
30.
30 of your affidavit.
No, that is part of the report.
Uh, In your affidavit, you have not explained the 3,000 benchmark.
The report, so I will
Okay, paragraph 30.
justify why we.
All right, paragraph 30,
No, no, page 30.
page 30, sorry.
That is
Yes.
part of annex of 5.
Yes.
Here, subsequent we go to the last part of page 30 till the end of that
Yes.
reply.
Moreover, that part. Moreover,
Yes. As per public.
we talk about 3,000.
3,000 have been spoken in the initial part of our reply. That's why I think what to do about it.
Reply,
It's reply. It's letter.
it's letter.
This is previous paragraph, page 29.
Start from 29.
Second. Construction of
Yeah.
building in a large scale until lots of pollution problem. If we do not try to mitigate this problem, we will be facing a situation where degradation of environment will reach to such an extent that it will be harsher place for us to live in the future. Construction of residential complex of 3,000 square meter will cause considerable sewage to adversely affect the environment due to pollution. Besides the sewage generated, the other associated factors like losses.
Where, how do you fix it at 3,000? Why not 2,000? Why not 4,000? Why not 5,000? Why 3,000?
So in
But
that,
there has to
in
be
that
some
case,
yardstick. It says,
so in that case, even for every
because you see
exam,
the
we need to
you see
justify
cen-
why we have set the.
but
path percentage of
something has to
15.
be shown because that central government notification which
That
you
is with
rely,
regard to larger
that
projects.
is
large
20,000.
projects.
And
large
here
projects.
you are saying
But here
3,000.
it is with regard to residential, whereas of projects of equal density with equal that
Thirty-
of a commercial
Look up.
establishment.
1 for us. Friday to 89 to 11. Is Saturday a working day, Mr. Chopin?
Yes.
Yeah,
This is a working day. I am, understanding is that the arguments are completed.
Yes.
However, I'm keeping it for Friday or Saturday. What is convenient? Friday.
Right.
Right. I'll try and dictate the judgment in the court, but let me have a look at it in case some clarification is required. Part third and list on Friday. No?
April.
Yes, Mr. Roy, you've been waiting for a long time.
This is a revision petition, my lord.
Yes.
Uh,
Or this is that case which
490 days.
Mr. Hajorika waited, preferred to wait till you join him. Yes.
My lord, the accused, my lord, after the FIR, my lord, was arrested on 27/3/2009. I think it was dated, Pahad for safety or I don't have the date, my lord. He married on 7/2/98 and, um, the wife then left, my lord, on 2/2/2009, my lord, span of 2 months or so. Now, the evidence is very, Lordship may see, the Ijahar first, my lord, at page 4, my lord.
But this is, you are challenging the concurrent findings of the trial court, appellate court. And so what is the law which has been ignored by the appellate court? What is the ground of attack?
But
We'll
no
put up
attack,
the
but
evidence later.
there is no attack. It's a normal FIR, my lord, and
No, no, not attack in the sense, what is the ground of
Ground.
attack for the appellate court judge?
there
On
is
what
no
ground are you saying?
medical evidence, my lord. First
There
of
is
all, the
no?
doctor has not examined. There is no medical report, neither medical report was called for from the
Medical
hospital.
report regarding the
Regarding my
injury,
lord,
torture.
really torture or something.
Is that fatal?
There is one statement which say that I've seen him slapping him. But that cannot be, my lord, a ground for, and it's very normal, my lord,
Let's read the appellate court judgment.
yes. But I need to read for the evidence part, but anyway,
No, no, this is not an appellate court, it's a revisional court. Let us first,
for the first judgment,
when required, this court will suddenly go into the evidence. But first, let us see.
first, my lord, page 26, my lord. That is judicial magistrate first class,
26.
page 26, my lord.
26 is the trial court.
Trial court judgment.
Appellate court.
33 is the appellate court judgment.
Read the entire judgment.
Uh,
33.
26, my lord, or 33.
33 is the
33, my
33.
lord, is the,
You are holding the paper book.
yes.
Locker, you have the paper book or not? Then you refer from the, read it from the appeal memo. The judgments are
I
not in
do
it.
have, but I have only the paper book, my lord.
Wait, this is, I don't know who, you have given the paper book.
Paper book is from, separate from the, office, my lord.
Is it? You don't have it. Then,
I did lost the file, my lord.
a revision petition by office. There was a judicial order for giving
There is
paper
order of
book.
the court, my lord.
Huh?
Lordship may see last lordship dated.
Yes, yes.
There is order.
Where is the steno? I'll see you. You have I'll direct the registry to give it to you and we'll fix it on another day. Heard Mr. J. Roy Leonard, senior counsel, appearing for the revisional petitioner. Stop. Also heard Mr. P.S. Locker, Leonard APP for the state respondents. It appears that the paper book prepared by the registry, though has been furnished to the Leonard counsel appearing for the petitioner. However, the same is not furnished to the Leonard APP for the state respondents. Let registry furnish the paper book to Mr. So-and-so, Leonard APP for the APP. Stop. Huh? Relist. After the this is not under date report. Ninth May. Mr. Roy, 9th May.
Item number 6.
Yes, Mr. Das?
In this case, my lord, 125 proceeding, my lord. But in this, the opposite party under the file petition, my lord, for other
Who is appearing for the other side?
other side, my lord, who received notice, but not there, and actually, he has expired.
Huh?
He has expired, my lord,
It expired.
expired. Thereafter, I filed one, my lord, IA, my lord, in this, I had to complete the, my lord, legal hair of the minor.
Anyone appointed? So that IA is allowed or not? allowed?
Allowed. Already integrated in the main case.
You have submitted fresh amended cost title.
Yes, sir, this is there, already corrected. 13 to
No one is there.
no,
Appointed legal aid counsel?
yes, yes.
Give me the legal aid counselor as an aid. This was done in, you have the order by which, when it was impeded, but then, notice has not gone up.
Not,
Then I'll issue notice or
uh,
the notice has not gone.
not, no.
Heard Mr. H. Das, Leonard counsel appearing for the petitioner, stop. It appears that pursuant to this court's order dated 13/3/2025, the legal heir of the sole respondent has been impeded in the petition. Accordingly, cost title has been amended cost title has been submitted. Let notice be issued. Steps with registered post AD relist after 4 weeks on a date to be fixed by the registry. Yes, Mr. Gogoi.
Order. Against the revision order. Just a micro.
You are in amicus.
Come number 1. 3. Expired.
1 and 3.
One, we already also have a debt certificate to account for it, and we have sought instructions
For 3.
also.
You don't have that now. All right, then we'll have it.
Number 2 also, there is some confusion regarding, it's been a while.
You obtain the instruction.
The bill is- Like,
By when can you get these information?
Since the 2012 matter, I'll take stay.
Mr. I keep forgetting your name. M. Sharma. The M. Sharma, the counsel for the respondent number 1, 2, and 3 submits that he has received written instructions as regards the death of respondent number 1. However, in respect of respondent number 3, though he believes
Yeah, that is expired, but status of respondent.
stop, huh? And he further submits that even respondent number 3 has also in the meantime expired. However, no written instruction has been received till date. He further submits that he has also reason to believe that respondent number 2 has also in the meantime expired, but he's yet to have any instruction in this regard. Keeping the aforesaid in view of the above, relist after 3 weeks on a date of the deduct after 3 weeks on such and such date for Mr. So and so to apprise the court as regards the status of respondent number 2 and 3.
Great. All right.
2 and 3, right? To get off.
Oh, you're aware.
No, the written, okay.
Correct.
And do the needful.
Correct. They appeal any conviction in a house burning case, madam. There is a communal riot against this group at Highland of There are two criminal cases, madam, for burning the second fire houses. So these houses, in one case, the other of the part, their cases have been, they got acquitted. But the case filed by them, they got acquitted. Normally, the two person have come,
Cross a fire.
the two person already died, but whether report is required or not. Police report is required,
2 persons have died.
out of 5%.
Five accused, 5 accused, out of 5
Yes.
accused. The law firm? The status report is of 13 matter. Jurisdictional police station can give it. You obtained it. Mr. S. Biswas, Learned Counsel for the appellant submits that in the pendency of the appeal, out of the 5 accused, 2 has accused number, appellant number.
At the moment, very difficult to say what I have been informed that some
He has
person died.
been informed that
Some person died.
who has died. However, he is yet to get written instruction in this regard. You're not in touch with anyone?
But this morning I telephoned.
What did they say?
They said that somebody died. So I asked for the medical death certificate.
But then why can't you give us the information? Why should we trouble
No, no,
the?
I'm not troubling my friend. The person is that the OC of the local police station sent the report. Because.
Mr. So-and-so locker at APB seeks 2 weeks time to obtain a report from the jurisdictional police station as regards to status of the appellants. Released after 2 weeks on a date to be fixed by the registry. Yes, next. Yes,
Done the 5 and my senior name is wrongly listed.
he had in fact made a mention in the morning. So, but who's your senior?
The D Taluka.
But earlier it says that which order says that you have returned and your names be struck off.
Actually, we have done a long back, we have returned.
But
Immediately after Muslim.
nothing is indicated here, Mr. Talukdar.
Because the file has been handed over to them.
But how can this is the appeal?
It's an appeal.
I'll engage someone. Then I'll engage someone.
Person can we see the order?
All right. That's what. Let me appeal. Heard Mr. Item number 9, no? Item 9. Heard Mr. D. Talukdar, Learned Counsel for the appellant. Also heard Mr. R.K.B. Chaudhary, Learned Counsel for Learned DY, SGI for the respondent. Mr. Talukdar submits that his office has returned the brief to the appellant long back. However, his names, but that I don't want to mention because there is no order of the court de-engaging you or you have not put any written instruction. So, Be that as it may, the appeal being a statutory appeal, this court, in the interest of justice, appoints Sri Devarishi Kumar Bhattacharya as learned amicus curiae to represent the appellant in the appeal. Let registry furnish the copy of the paper, a copy of the appeal memo along with all the relevant documents to Mr. Devarishi Kumar Bhattacharya, learned amicus curiae. List after 3 weeks. After 3 weeks on a date to be fixed by the registry. Anything, Mr. Anshanti? I am not saying. In fact, I have not. You have not. Mr. So-and-so also submits that he does not have a copy of the appeal memo and so-and-so. Let registry give it to Amicus Curiae as well as Mr. So-and-so. All right. All right. And names of Mr. B. Talukdar
That is
and his juniors, we start off from the first list. Get ready. All right, Mr. Talukdar.
In item number 10, Lordship, we have checked the trial court record has not come, only the appellate court has. The conviction was by the magistrate for 6 months. Thereafter, they preferred appeal. That was also dismissed. Now revision petition. The trial court record is not there. I have checked. The evidence is also not.
Was it called?
It was called.
It was trial court or an appellant? Or TCR was called.
The appellate courts answer has come, but the trial court answer.
Mr. D. Talukdar, and counsel for the petitioner submits that though the records of the appellate court has been received by the court, however, the trial court records have not yet been received. Let registry forthwith call for the trial court records. Relist after 3 weeks on a date to be fixed by the bench.
Master.
All right.
For little accommodation.
Huh?
Little accommodation, but I have.
Mr. Bhuya has
My
been
brand
sitting
is
here
waiting
since,
this
I
morning
think since
For this matter.
10:30.
Now it's been informed. It's been informed.
And then you were sitting next to him only.
Yes, we are talking also.
You did not inform him.
But just Pondopotaki informed me that he cannot come.
Oh, acha. He had engaged you in
He,
this,
no, he is the advocate in this case. Madam.
oh, not you.
I also hear, madam, from the beginning of the case, madam.
I'll leave it to your lordship to speak. Let it be after vacation then.
Mr. A mention is made by Mr. S.C. Biswas on the ground that Mr. P. Kotoki,
Yes.
he's who? He is assisting you. P. Kotoki.
I am also taking assistance for him, he also taking assistance. He is a vice versa.
Mentioned. Mr. S.C. Biswas makes a mention for posting this matter after a week on the ground of personal difficulty. Prayer is not proposed. Relist after 3 on a date to be fixed by the registry. And on top, you say heard Mr. S.D. Biswas, learned counsel for the petitioner, also heard Mr. A.K. Bhuya, learned counsel for the respondent. And anybody else is there? State is there? And PS offer, it will be for the state president.
But I pray that to reflect the name of the Kotaki.
Kotoki is already reflected. How much?
Then already.
It is already there.
God bless.
Huh?
This matter is a very short matter. What happened, madam? There was a market between the two groups of the party. And as a result, madam,
RP.
one person sustained injuries of P26 and subsequently he died in the hospital. As a result, my lord, P02 was added and case was charged. This petitioner, along with other persons were charged. But this petitioner was a minor. We have produced the, after charge sheet, we have produced the 238 and London Session Judge has examined the headmaster. And other local witness also here brought as a court witness. But he is not satisfied about the plea of minority. He said, no, he's not a minor, he was a minor. So our contention was turned out, for which we came before your lordship in revision. Now, only ballot, his evidence, but I will read out if impugn order, my lord, at page 30. I have already nine number of accused, including the so-called juvenile Madhabuddin are present. I have already heard learned counsels of both sides of the matter on plea of divinity of Madhabuddin. During hearing, learned defense counsel submitted a decision of the Honorable Supreme Court as published in 2012, volume 2, SCP Criminal 864. Relying on the decision, learned defense counsel has submitted that school certificate as submitted for Madhabuddin showing the date of birth 15 to 94 is to be read upon in pursuance to any other evidence and voter list. Probably this is the second law, which is certificate in all the cases. And if the same is believed, Madhabuddin is to be declared as a juvenile as on 10th of April 2009 when the occurrence took place. The date of alleged occurrence for the purpose of determination of age of Madhabuddin, 4 number of witnesses were examined as court witnesses. Witness number 1, Sabitul Ahmed, a head teacher of the school, according to him, Madhabuddin got admitted in the school in class 1 on 10/3/2000. At the time of admission, he recorded the date of birth of Madhabuddin as per the declaration made by the father of Madhabuddin, who continued study only for 1 year in the school. He further deposed that, as per the GOP circular, even without birth certificate, a person is to be given admission for the purpose of Sarva Shiksha Abhiyan. However, he insisted for proof of birth which father of the Madhabuddin failed relevant entries in the school register are proved. TW2, so it is about a court number 1. Court number 2 is the son of the deceased of the case. According to him, he is the next door neighbor of Madhabuddin and he knew Madhabuddin since long, and according to him, present age of Madhabuddin is about 28 years. The court witness number 2 brought copy of the voter list for the year 2005, where the age of Madhabuddin appears as 18. Exhibit 2 is the voter list. His further evidence is the Madhabuddin is the contemporary of his cousin Zakir. Age also appears to be in the voter list of name 19. His further evidence that the age of Madhabuddin in the voter list of 2011 appears as 23, and present age is about 26, 27. He also deposed that his second son, namely Jubail Ahmed, at age of about 20 years, is younger to Madhabuddin. Similarly, the next door neighbor, Madhabuddin, namely Jubir Ahmed, as quote with number 3, deposed that Madhabuddin is known to him since childhood. According to him, Madhabuddin is 6-7 years older to him. He exhibited his birth certificate showing his date of birth of himself. TW4 has said his accusation as next door neighbor of the Madhabuddin, who has deposed that the Madhabuddin is 1 year elder to him. He has further deposed his present age is 27. According to Lanes PP, appearance of Madhabuddin tends to be suggest that he was not a juvenile. Probably this is not correct also. Tends to be is not a juvenile. At the time of alleged occurrence, in the forwarding report dated 13/4/19, that is 3 days after the alleged incident, age of Madhabuddin is mentioned as 24 years. According to PP, this mentioning of age in the forwarding report also shows to suggest that appearance and accused did not suppose that he was a juvenile. As such, IO has mentioned age of Madhabuddin as what appeared from the appearance. It is seen that the certificate of school procured after 2 years, after the alleged incident. Except certificate of school, there is nothing to suggest Madhabuddin as juvenile or below 18 years at the time of alleged occurrence. This is not a borderline case, as plea of difference of age, Madhabuddin is about 6 years. That what of forwarding report. Therefore, according to the learned PP, the age of Madhabuddin has been below 18 years. It would not have been overlooked by the standard court below or the investigation officer. So also it is
So
argued
the
that
only
it is as per
certificate,
the
only,
evidence of
only certificate that you have relied is the school certificate.
all is happy. But probably this is the law. Supreme Court of held that nowadays in all the evidence regarding age, certificate is the case. Even medical report is over.
JJ, this is of 12.
Yes.
So JJ Act has, JJ Act will be applying, applicable 2012.
Yes.
JJ Act. Now, when there is a doubt about,
Ossification test was not.
huh?
Ossification test was also not.
No, that is not required to be
Not
done.
required, yes. Why there is certificate?
There is a manner in which, yes, Locker. This is the order under challenge.
In this respect, my humble submission, the Supreme Court judgment is already settled law regarding certificate.
Which one?
This has been reflected here by the defense counsel. And thereafter also there are so many judgments on this point, madam.
Where is the
SCC
judgment?
2012, volume 2, criminal
Where are you,
864.
are you carrying it?
I have not got it.
You bring it, Thursday. Release Thursday. You get the citations and see the law
Sure,
also,
sure.
because merely on that it will not apply.
Yes.
What the law says, that
Yes,
section
that is true.
30. And the rules. Release.
Okay,
Yep, you must come with all the books.
I'll go, sure.
Number 14.
Our main problem is because we do not have the record, any records of in our office, the office. It's all the letters related to 19, prior to 19 or 20.
13. If you have difficulty, this court will accommodate you. Have a, can ask them, yes, yeah, in this, do you have or you don't have? You provide a copy of the petition to the APP. All right. You want time for, on what ground?
Engaged counsel is asked special law.
Mr. Udin,
Yes, sir.
your name?
P. Udikari.
Huh?
P. Udikari.
MSP Odhikari Learned Council submits that the engaged conducting counsel, Mr. G. Udin, is out of station and accordingly seeks accommodation in the matter. Mr. B. Sharma, Learned APP for the state respondent submits that he filed that a copy of the revision petition that did not have a copy of the revision petition. Let a copy of the revision petition be served upon Mr. So-and-so by the learned counsel appearing for the petitioner. Relist after 2 weeks or when? You give a copy. 15 also same.
Yes, sir.
15 also, we don't have a copy. 15, you want the copy, you don't want the copy, Mr. Lockor, make up your mind. Because he's taking time. Not required. Then 15, the other person did the copy person alage. Date did you go 15 of? Okay. Same, huh? 15. And appears for the petitioner on call. Mr. Locker is so-and-so is present. Relist date given next week. That is subject.
Item 17.
And appears for the petitioner when the matter is called. It appears that on the last occasion, I-6/3/2025, also there was no representative on behalf of the petitioner when the matter was called. In view of the consecutive non-appearance of the petitioner, learned counsel appearing for the petitioner, the petition stands dismissed for non-prosecution. On top, you give the presence. You are there, right? Doctor.
So 18. In this case, Lordship, I'm appearing for the opposite party complainant, Lordship. The appellant were convicted by the trial court. And thereafter the appeal was referred, by the accused appellant. That was
Why are you
also
not,
dismissed.
why are you not allowing the petitioner submit, Mr. Agarwal? You want some time today?
No.
Yes.
Not in the morning, as I have not taken consent.
Oh, this is that matter. Why you want the time today?
There is other thing,
Who is your senior?
sir. Further,
When is he coming back?
I said today itself, but
There is urgency, Mr. Agarwal? You want it this week or next week?
This week, Lordship.
Your name? MSM Sahu, Learned Counsel, appearing on behalf of the petitioner, seeks accommodation on the ground that the conducting counsel, Mr. N.N. Jha, is out of station and is out of station. Stop. Mr. S.K. Agarwal, Learned Counsel, appearing for respondent number 2, does not object to the said accommodation, but seeks a short accommodation. Relist, data that video construction section.
I did.
Last 7 years, my lord. It is crime against minor, your lord. Stay has been granted by the court as party.
Where is the petitioner today?
My lord, whenever the matter listed, my lord, that they took time, your lord, without informing me, my lord. Because of
None appears for the petitioner on call. Heard Mr. A. Goel, Learned Counsel for the respondent number 2. We list on Friday in the order column with the remark for dismissal. We'll see on that day. If they don't appear,
on very long
okay.
time omitted by my inspector, police inspector in police station.
Legal aid counsel is there.
I am appearing as a night spirit for respondent number 2.
What about the legal aid counsel? Earlier appeared or not appeared?
Has been discussed first and after I have been appointed as a night spirit.
You are Priya Garwal. You received the paper book? You're appearing for the respondent, right? Appearing for the. Huh?
Yeah.
Saying, Saikya is also shown as a legal aid counsel. Right? Stop appearing. None appears for the appellant on call. Heard Dr. P. Agarwal and Amicus Curie for respondent informant and P.S. Lawford and TPP for the state respondent. It appears that Mr. P. Saikya, Learned Legal Aid Counsel, despite the name being reflected in the cause list, has not appeared. Is absent when the matter is called. Missed. The interest of justice, so and so is appointed as an amicus curiae to represent the appellant in the instant criminal appeal. Let registry furnish the copy of the paper book to Mr. So and so, Learned amicus curiae. Relist after 2 weeks. Date na di ba na relist on such and such date. Okay. Mr. Shri Surajit Das. All right. Yes, Mr. Sharma.
The background,
FIR 420, 468, 471.
yes. The background.
Yes.
Pertains to the appointment of public inspector.
Background.
That's the background.
Background is required.
Yes,
Why? No, it's a washing,
yes. So
fire washing.
if I was sitting in the deputies where of the appointment of the petitioner vis-a-vis the unsuccessful candidates was already carried out, and there was a finality to the entire episode by the Honorable Court in the year 2014. Thereafter, same issue have been raised by the informant, the number two, by way of an FIR, subject matter, stating that the petitioners have forged their way into the parliament,
Watch there.
way parliament. That is the gist of the issue. The lordship can.
It is different, criminality is
It is,
different.
It is, but there's a. back-
Let's go to the FIR.
Yes. The FIR is what is the page 87.
It will come from where? Agar. Monday? Monday? Monday or Tuesday? Huh? Tuesday. Heard Mr. M. Sharma, and counsel for the petitioner. Also heard MS. RS Diori. Here, the counsel appearing for R2 and PS Lawford and APP for the state respondent. Mr. Lawford Mr. Lawford seeks submits that the perusal of the case diary shall be essential for effective adjudication of the criminal petition, and accordingly seeks time to place the same on the next date of listing. Where is allowed, let the case diary be produced on the next date of listing. List on such and such date.
I'm good. I'm good. Release.
I've been furnished with the judgments of the, although I've been submitted a copy of
Sorry,
judgment of the
Mr.
court,
Chaudhary,
but I have not been submitted with the deposition of the witness.
everything is not given. You have been given only the
Copies of the judgment of both the trial court as well as the appellate court.
Mr. U. Chaudhary, Leonard Amicus Curie submits that though the copies of the judgment of both trial court as well as the appellate court has been furnished to him by the registry, however, a complete set of the revision petition and the case records connected and the case records have not case record. Case
No,
record is
Lordship,
required to be
that-
given.
Deposition of the witnesses, Lordship, because it is a revision, Lordship, I have to go to the trial court that was. The deposition of the witnesses.
Can be given. The case records have not been given. Let registry furnish the copy of the case records along with the complete set of the criminal revision petition to Mr. Suan Chaudhary and Amicus Curie.
But the revision petition, I have got it.
You have got it,
Yes, only the deposition.
case
part.
record. Huh? I'm saying case record we
Lordship,
we list
first. Obliged.
Then we'll just wait.
and appears for the petitioner on call. It appears that on the it appears that on the last occasion, I 23/2025. Also, there was no representation on behalf of the petitioner. It further appears that on the last occasion, I 23/2025, also that it further appears that this court on 2025, after noticing that the matter was last listed before the court on 27/7/2012, directed the registry to intimate the learned counsel appearing for the petitioner the next date of listing. I dated 1/4/2025. Office note dated 29/3/2025 indicates that the registry has contacted the learned counsel appearing for the petitioner through her mobile phone number I 986-410-7553 and intimated the next date of listing. And also requested her to receive a true copy of this court's order dated 23/25. However, the learned counsel for the petitioner did not receive the same. Since today, despite the name of the learned counsel appearing to the petitioner being reflected in the cause list and the registry having informed the learned counsel for the petitioner as regards the listing of the matter today, there being no representation, this criminal petition stands dismissed for non-response.